that is being uploaded now. The time we worked together was based on justice systems which are over-criminalizing women or feminized identity people, as well as people with indigenous traits. And the question here was how we could improve this. Out of that discussion and after that brainstorming and of all those experiences I just told you about, we got this prototype called Denoracle, and it is a tool that allows to raise complaints about situations by people in prison or indigenous traits. We understand that their context in the context of these people, we mentioned these people, they have a very difficult situation. And what we thought about facilitate the possibility for raising complaints against violence acts for these two groups. They should not be afraid of raising a complaint even within prison. Furthermore, we thought that it was important to consider the family follow-up side. It's important for an intern to be constantly in contact with their families, so with MPIA, and to make it more graphic, I will jump onto the platform. Now I'm going to share what the platform looks like. There we go. Above all, I would like to thank one of our colleagues of the team, Perla Maria Alcantara Ramirez. She is the one who designed all of this platform. While we created all of the ideas, she was the responsible for the physical, let's say, electronic prototype, so we could see how we could use it and how it may look like. So this is a platform that will facilitate the linking between the justice system and the citizens. As you can see here, we have a chat, and in here we can write something, anything. Let's say a question. Hello, how can I raise a complaint? That would be the question, and the chat is going to reply by saying, hello, please leave your interesting aspect of this. We know that there are several states with a similar system. However, artificial intelligence in here is going to support several of the problems we encounter during coordination. For instance, we found out that there were public prosecutors' officers with a lot of work, and as well investigation police that had the same problem. So what did we do? We generated or we implemented artificial intelligence. What for? As to decrease the workload and for this to be streamlined. Now we've got a tab. I'm speaking about the page here. I'm sorry, Yoder, if you could start closing, please. Yes, in this case, each one of the tabs allows us to approach both the authorities and the authorities to us. And so we can have an integrated standardized investigation file, and we have exclusive tab for the investigation of police, one for the public prosecutor, and training here. So in a nutshell, that's our proposal. Now, we focused on solving this type of problems because those were the ones that we detected. We know that this is a fully multifactorial problem, but we tried to cover the main ones. What did we learn from all of this? Well, teamwork, the use of multi-varied ideas. Either they are according to the profiles. On the contrary, all of this is triggering. The problem was very interesting, and a methodology, in this case for social sciences, that allow us to have a study in what applications do we have this for our life. Well, for the methodology for ordering ideas, professional networking, and the enriching of ideas. So, well, I join Adrian. Thank you very much for allowing us to take part in this event. And we hope that we will have more workshops in this sense. Thank you very much. Thank you very much, Yadira. Thank you for the effort to try to summarize such a big effort and exercise. And I think that it's important to say that its results, not only results are important, the solutions to which you got that quite surely will be useful for several authorities to take ideas from here, and also to learn on the way, and to get to know what the process meant for all of us, of the process of applying a methodology thought for the users, and to dare propose different things. Thank you very much to both teams. Thank you, Oscar. Thank you to the facilitators team. Thank you, Edna Jaime, for promoting these efforts. Quite surely we will have more. And we invite everyone who is interested in joining this practice community to continue the discussions and to share any bibliography with us in a chat that we're going to be opening up so we can create this practice community. You can join from the link that we're going to enable on our platforms. And without it, we're going to be enabling the different materials on the documentary memory of this exercise for these ideas, and not just to be on paper. Thank you very much. So we're going to start with the activities of the third day of the Innovation Farm. Thank you very much. Thank you and have a great day.
Muchas gracias a todos y a todos los que nos siguen en este segundo Foro Internacional de la Innovación en la Justicia. Sin duda muy interesantes los resultados y muy inspiradores el esfuerzo de construcción que hicieron los equipos que participaron en estas mesas de trabajo. A continuación, platicaremos sobre la modernización sustentable del acceso a la justicia. Nos acompañan como moderadora
We have as a facilitator Irene Tello, Executive Director
Eva
of
Ortiz,
Impunidad Cero,
de Justicia Digital del Banco Interamericano de Desarrollo,
Eva Ortiz from
Thomas Fabenac, Director Ejecutivo de
Justicia Digital from
LAFCO,
the
y
Inter-American
Hugo Concha
Bank,
Cantú, del
Thomas
Instituto
Fabenac
de
from
Investigaciones
LAFCO, and
Jurídicas
Hugo
de la
Concha
Universidad
Cantú from the
Nacional
Institute of
Autónoma de México.
Judicial Research
Muchas gracias a
from
todos.
the
Les
National
cedo la
University in
palabra a
Mexico.
Irene Tello.
Thank you,
Muchas
everyone,
gracias.
and now I give the floor to Irene Tello. Thank you, everyone, and good morning. I am Irene Tello. I'm Director of Impunidad Cero. It's a great pleasure for me to be here with everyone, especially talking about a topic that I think is vital with the current events, with the pandemics and all the pandemic and all the challenges that we have in the justice system to be able to have modernization in a sustainable way. What do we mean by this? What would be the necessary mechanisms to implement technological tools from different types that allow better access to justice, that make justice more efficient and the necessary conditions for the application of these innovations in the justice system in Latin America? What would be these necessary conditions? And also, I think it's important to mention how to strengthen these new mechanisms or technological tools that are being used right now in justice. I think these are vital questions. In Impunidad Cero, we have dedicated a great part of our job to how we can use digital techniques for access to justice. And just to give you an example, it may seem very simple, but it's related to how to put a claim in this country. Something that we realize is that many institutions in Mexico do not have these tools for citizens to have access to justice, to reduce these numbers that are so high in Mexico, so that the citizenship has alternative channels with these institutions. But there are also other things that I think are very important to mention, and it's a great pleasure for me to talk to the people who we have here today, Hugo Concha and Thomas Fabenac. I'm going to read a small biography of each of them. Hugo Concha Cantú is a researcher in the Institute of Judicial Research from the National Autonomous University in Mexico since 1994, and he's also a lecturer there. He also teaches in the National Autonomous Institute of Technology in Mexico in law school, and he has created different publications regarding the judicial system in Mexico. Additionally, he is director of the magazine Reforma Judicial. Thank you very much, Hugo. And now I'm going to introduce Thomas Fabenac. He is co-founder and CEO of LabCo. He has more than 14 years of experience collaborating with the public and private sector, as well as civil society organizations in Brazil, Colombia, Ecuador, United States, France, Mexico. And since 2014, he has been living in Mexico, where he has coordinated different implementation and design projects for the assessment of public policies that are related to violence, policy reform, the strengthening of the criminal system, and forced disappearing. And he has collaborated with different cooperation organizations and international agencies such as ANID, the British Embassy, and UNDH, as well as the Mexican federal government and state and municipal governments from different entities. He has a master's degree in the Akali School from Harvard University, and he has a master's in business management in ESSEC Business School. Thank you very much, Thomas. And I will introduce the questions so that we can start with the first part of the session, and I will give the floor to Hugo Concha. Thank you very much. Okay, so I can speak now. I am very glad to greet you, Irene and Thomas, and the audience that is with us this morning. And of course, I would like to thank everyone for this important initiative of being able to talk about these topics that not only are they good ideas, but also they are necessary to move forward and modernize the justice tools in Mexico. In general terms, I think that justice, well, I think this is not very political or convenient, but the conditions that our justice system, specifically the administration of justice, is one of the greatest concerns that we should have as a country. This is stuck, this is not good, and we're having very serious problems. And criminal justice has very strong implications in the access that people may have to it. I'm going to give an overview on how I understand this topic that we are here to discuss. This is a complex topic. Talking about modernization and access to justice are complex topics, but if we also add modernization that should be lasting, that should be maintained in the sustainability of this modernization, I think this becomes even more difficult. I will start by doing a strong characterization of how I do this in Mexico, how I see this in Mexico. I would mention 4 words. I think it's unequal, first of all. I think this is something that we all can see. This is one of the countries with the highest rates of inequality. It's not the same to have justice for a person that has the resources, middle or high income. It's not the same how they are going to face a justice problem than a person that lives in poverty. This is with different lenses and different measures that justice in Mexico is, especially in the criminal branches, a justice of the poor. And this is because that's the people who is facing this justice with really bad results. So we have this problem of inequality. We also have complex justice. What do I mean with this? Mexican justice, the procedures and the formalization of the regulations that give access to justice is very complicated, is illegible for most of the population. We live of this, we make a living out of this, but explaining a ruling, what this means, the different procedures and what they are, is difficult. We don't have an easy access justice in our minds for people to understand clearly, for them to know that in a conflict of a certain characteristics, whether it's civil, criminal, family, or labor, they don't know where they have to go or what they have to do. People don't know that. So that creates an opposite reaction, a certain reaction of people trying to avoid it. So people think that it's better to know the least about all of this. And that's another problem. So each of these problems takes to different places, which is what I would like to mention later. A third characteristic is that we have a very expensive justice. Even though we say that justice in Mexico is free, it's not. Since it's so complicated and it's such as a labyrinth, people need to look for the experts. They need to find the lawyers that sometimes are not good, but they need to receive help in order to have access to this justice. So it's expensive in economic terms, and it's also expensive in time, because if there is something specific of the Mexican justice is that it's not expedite. It's a justice that takes really long time. It has so many gaps and so many different and difficult things, is that it's slow and it costs time. It takes time for people who need to have access to it. And the fourth characteristic is that I would say that access to justice in Mexico has inefficient access. The results are something that we cannot find at a medium or short term. People don't know what they are going to reach, and what they are expecting, it's not what they receive. What this justice is not achieving, which is key in this constitutional area, is to receive the solutions that they require, and that does not exist in Mexico. So I repeat, access to justice is unequal, complex, expensive, and inefficient. Thank you. Thank you very much, Hugo. You are bringing very important points to the table. What you just mentioned about people not knowing where to go, what authorities to go to. In Impunidad Zero, and I'm sorry if I am advertising this, but I think it's very important, we had to develop a platform called denuncia.org so that people can have access to this, because when people are victims of a crime, they are not thinking about taking an official ID, or what happens if their ID was stolen, what is the process they need to follow, what they need to bring there, where is the public prosecutor's office that is the closest to them. So these are the things that put obstacles for access to justice. Now I'm going to give the floor to Thomas so that he can mention a little bit more about the necessary mechanisms in order to implement at a long term tools that make justice more efficient. Please, Thomas. Thank you very much for this initiative of this forum and for the invitation to contribute. LabCo is the name for a laboratory of collaboration. We are a laboratory of innovation. We talk about citizen justice and human rights. So we try to collaborate with local actors, with the Attorney General's offices, with the law enforcement in the area of disappearance so that we can find this innovation and for its functions to last. So for this first intervention, I would like to mention some things. The first thing, and as a follow-up to what Hugo mentioned, the innovation that is given in terms of processes and technology in the world, in the public and private sectors right now are having a really low impact in the justice system in Mexico. The justice system in Mexico has a lag regarding the methods or processes and technology, and it's actually resistant to change. So the challenges that we face when we are trying to improve or move forward is really strong in this justice sector, and it's similar in security. I think there are several clues to try to move this, and we're trying to create different experiences or working methods that have been used in other disciplines in the last few years. The first element is this idea of the user. Sometimes when we think about a change, I don't know, in a general attorney's office, we think about the processes, the indicators, how this is going to be seen. And there are a lot of processes that are being developed that are ineffective for the users, the victims. And on the other hand, there is a great resistance. In English, we call them the frontliners, for the people that are at the front, the people in the public prosecution. They are going to use these new methods. So I think that the first element to think about a change in a sustainable way is to think where this change comes from. So it starts with these people that are the users, and very few times it's the route of the victim, the real experience of the accused or the daily life of the public prosecutor or the attorneys, so that we can start creating these first changes. So I think that the change of paradigm is that these people are not only part of a marginalized interview, but the core of the change. In second place, we have these methods, these implementation methods to think how to address this. Very few times we have the users involved. I have seen that many times, whether it's from the institutions or international cooperation, we have the experts, we have a great diagnosis and a great plan, and they say this is what we have to do. And we have a great plan of transformation that is agreed on with the top positions, and then they are not implemented, and then there is a change of administration, and then we have another one. And there are a lot of protocols that have been developed to manage criminal cases in Mexico. And I think that this way of working on change is obsolete, and it has proved that it fails. And there are different experiences that, mainly in the private sector, that have moved also to the public sector. We can call it design thinking, or what we have done in Mexico with these 100 challenges, 100-day challenges. In Harvard, there are different projects for adaptation, and they share this same philosophy. We need to define the results that we want to reach, but we should not define the great plan that people need to follow. We need to establish teams that put in the line of the construction the users, the public prosecutor that is going to use the process and the technology, and we need to work with short cycles of trial and error, of feedback, around 2 weeks, so that we can move forward. And then we start with these practices, and once this is working and it's already part of everyday people's practice, and then we do the protocols, and then we do the changes in the law. And then we make sure that changes are built by the people who are going to operate them so that it works for them. And once it's being used, that it works for the context where it's going to be used, not in a laboratory in Chicago. And then we can move that to the law. Sometimes we think that we create a law and then the world is going to change by itself. But I think that the main point is to start with the people that are going to use these changes. Thank you very much, Thomas. I think that it's a time to continue addressing this before going to the trigger questions. I think this is a topic that may seem very easy, but due to the different types of innovations and modernization processes that we may have and the points that Hugo mentioned, this is a process that is so complex and works so bad that we need to consider where do we need to apply this. And we have the operators of the justice system. Are we thinking about the user? Are we thinking about public prosecutors? Are we thinking about police officers? What part of the process are we going to modernize? So I think we need to establish what are the challenges and the questions of each of them. And I want to hear you, Hugo, again, so that we can go deeper into these topics. Yes, Irene, thank you. I think it was very interesting, not because of what he said, but the topic he's talking about. It's about the how. You were pinpointing it in a more generic way. I think this is a puzzle of many actors in the justice system. So I necessarily think that for more specific recommendations, we need to go to every micro space, so to speak, to each specific scenario to determine what is the best road to follow in this modernization. Because as Irene is saying, it's not the same. If we talk about having contact with the public prosecution or with the police officer, it's very difficult and very different what we are going to reach with the judges and the formal and judicial procedures. So I think that this segregation is like the first fundamental step that goes hand by hand with what Thomas mentioned, which is the human aspect, which is key to achieve modernization more than the great ideas or the protocols that we want to have in paper. We need to start with the human aspects, and we need to see the need and then detect the change so that we can improve. Because many times we start the other way around. We start from the great plan of modernization and this great plan of doing things when the people that are going to use it do not understand it or know what to do with it. And this goes with the different characteristics that I said. It's actually very difficult. And then if we add this, these possibilities of modernization are totally failing. I would think, following the lines of what I mentioned previously, this opens a lot of doors on where to find the necessary tools. If I go to the first axis of the unequal access, inequality comes in a lot of ways, and I cannot mention all of them because of the time, but inequality comes in different ways, not only in the type of social status that justice is looking for, but it comes from the different spaces as well. There are different spaces that may be very efficient and easy and good, and sometimes they are, and sometimes other spaces are working properly and other spaces are not. For instance, currently the information, the data that we have from the federal public prosecution, it's good. It's a space that is helping access to justice in the federal justice, in the federal courts, and maybe not in all the areas. But this is kind of a puzzle that I mentioned. And this first access as a great topic, I think that something that is missing is to have competent legal advice in order to make this inequality more homogeneous, to provide access to justice in general terms as well, without entering very specific spaces. And we need to see how and when, but I would need to see that the topic that we need to talk about when talking about inequality is related to competent legal advice. I think that's something where we can say to have strict controls on these judicial officers that are in touch with the citizens. About complexity, this is a whole issue. I think it's related to training and education, but this is also related to another phenomenon. The Mexican justice system is so complex because everything that has been accumulated, and this is related to the origins of our legal system and the institutions, where they come from, where did we get them from, how we established them, and we created a system that is so formal that it's completely dark and difficult to process. So this historical formalism and the rigidity of the profession makes access to law a world that is actually very complicated. I would think that sustainable modernization needs to move forward, starting from the language and then from its procedures. And this is also along with education and training. And having access to information. And also talking about the cost. Irene, I'm a little bit lost with the time. I don't know how much time I have. I don't know if I have 10 or 5 minutes. Okay, yes, they are asking us to finish this intervention. So yes, I think it's very important that you finish your idea. Yes, regarding the cost, I think it's something that we need to be very clear on. We have these long and dark procedures, and what this has created, it has created high costs of transaction and a lot of corruption. We do need to rethink how we can simplify and make justice cheaper in Mexico, but this is related to these other factors. So I would say that cost is a key topic, but should be checked in the end. I would go first to training and then to legal advice, and also education and training that I think is fundamental. And there's an extra one that I will talk about. I will just mention it without elaborating. And we have this access of an inefficiency to access. I think we need to have a simplification of the regulation, and we need to detect opportunities. I'm going to close with that. I will not say anything else because I am over my time, but I will talk about it later. Thank you very much, Hugo. I think that you are establishing very relevant points. Each of them requires a lot of details, and I think that what you're mentioning, the excess of formalism, is something that we need to talk about again, because it has to do with a lot of factors. Regarding impunity, I think that the excessive formalism that we have in Mexico is one of the causes that we have for impunity currently. And I think that we need to talk, as you say, how to allow more people to have access to a quality legal advice. I think that more projects such as Abogadas Violeta from the civil society, they are lawyers, female lawyers that are offering advice to women that are victims of violence. And a woman that is deciding to start a legal process they do not receive a proper legal advice, and they are re-victimized by the authorities when they are trying to report. So I think this is vital, and we can get all the talent that we have from all our law schools. We have a different degree in law every time, and I think it's important to review as well the quality of this studies all over the country. We have so many lawyers in the country. I think we need to take advantage of this so that we can provide good legal advice instead of people doing their social service, only taking photocopies, and they should be doing useful things. And now, Thomas, I will give you the floor so that we can close this first idea that you had on the previous presentation, and then we can start with the specific questions. And we can also take some of your comments from your interventions. Thank you, Thomas. Yes, maybe a comment on where we started. And I also have some reflections on how technology, specifically the new developments of artificial intelligence, can be a support here, but you will tell me when we can talk about it. I think that the starting point is to think about justice as a public service, first, for citizens. It may seem basic, but in very few times, the behavior of the institutions and the people that are part of it is what is related to it. Many people here have been to hearings, and the behavior of the people in the public prosecutor's office is not necessarily close to what the victim requires. Even though if they are representing the government, this is a service for the person, so that in the end, their cases don't go with impunity. So the starting point, I would say, thinking in the structure that justice is a public service for real people who are victims, and also for the accused, depending on where we are. And it should establish what we should do, the language that should be used, the modalities of the contact. What, for instance, you were robbed, someone robbed your cell phone on the street, and they tell you nothing is going to happen. Someone needs to explain this properly. So the starting point for me is to see what people need, specifically people who don't have a way to fund a private service, and that the processes and the methodologies of the people should be adapted to that. And then the system needs to move starting from that. There should be a lower amount of victims if we have better prevention. What the police does needs to work for people. The justice system as well needs to work for a victim who wants to solve their case, as well as for an accused person. And a starting point to understand the rest of it is understand what people need, thinking about this public service. And also, I'm going to link this with the modernization and technology part. Thinking about people, part of the strong developments from the last 5 years is the completely massive use of WhatsApp and messaging services. I speak specifically about WhatsApp because it goes beyond social classes and generations. We were talking about the pandemic, and you both are teachers, and many people had problems with Zoom, but everyone knows how to use WhatsApp. We know and understand it, and we use it. And in Mexico and in many places in the world, we don't have balance with prepaid balance. WhatsApp still works. It doesn't need money to be activated, as well as other messaging services. This is very powerful, and the world understands it, and you may see it in different pharmacies here in Mexico that are in this channel. In the technology part, there has been an increase of online platforms. First of all, they started with websites, then we moved to apps, and then there are some mechanisms that have been taking advantage of the fact that there is one channel where I can solve things. You can write through WhatsApp to ask for a product. And there is a window of opportunity to have access to justice by leveraging these opportunities, by seeing this reality. In the economic sector, there have been some elements. With the vaccinations, I was able to receive my certificate by sending a text through WhatsApp. And from LabGov, we think that this is something important. We are developing some prototypes. We do it with 2 artificial intelligence companies, where along with some general attorney's offices, we have created a prototype to leverage these messaging services by using these services. And we can see how this has been, how we can use it. This creates benefits and it saves time for people. But also the fact that the general attorney's offices are saturated, this allows us to improve the large amount of people. And also, sometimes these platforms, what they do is that they also allow to respond partially in an automated way. And it also allows to connect remote agents. So we may think about these lawyers that you were talking about in the country. We may have these legal advice services all over the country, and it does not solve everything, but it allows to leverage these tools that we have that once again go beyond social classes and generations.
Las abogadas Violeta ya acaban de inaugurar su bot, que les invito a todos a que lo conozcan en la página de Facebook. Entonces, si tú le escribes en la página
I invited to check the bot that has just been created, and actually that's what we're going to be asking, what you need. And is this do you have a legal problem, you can leave their information so they can better channel you with the lawyers that can provide you with this. Because these questions that take time from a person, as you said, this could be automated. And I think that this would be a pivotal tool. And I think that, as you were saying, there are no prosecutor officers that have this already, because oftentimes I think that the lack of trust concerns things as simple as, I'm going to raise a complaint that I was robbed my mobile phone because I need this for my insurance, and then nothing else happens. And then we're like, we do not have enough information as to continue with this investigation, but your complaint is very important as to identify criminal patterns in the city. Just receiving a simple answer, maybe if it's not the one you're waiting or expecting, this would make a huge difference with respect to the trust and in terms of the treatment that people feel. Now we will go to the questions. What you just mentioned, Hugo, it's very important. Consider inequality, complexity of costs. So approaching this last point to go into things that you would recommend, what could be done with regards to the points that you have just considered, as Thomas was saying, as a starting point, or success cases that you've seen and that could approach us further to what could best work in the country to have a better access to justice. Thank you very much, Irene. We're going now to the more complicated cases. It's difficult for me because I think that to do this well, and we need the Thomas approach. What we were saying before, this is disaggregated. Access to justice is not the same for a woman in case of violence. I'm just going to imagine an example. In Mexico City, right? I don't think it's the same to a situation and problems of access to justice for the same situation for a woman in the mountain ranges of Oaxaca, where quite surely we have gender violence, which this is going to be completely ignored when the problems of the public prosecutors are focused on disappearances. So we have to go into very specific questions here for specific scenarios, not with the generalizations. Since we have very little time for this discussion, what I would say is that four main axes that can be used in a very theoretical matters, which are abstract, of course, I acknowledge that. That's why I was speaking about disaggregation, but they are relevant for a sustainable streamlining, as is the title of this table. Without a doubt, the first and most important one is, and you're going to like, okay, wow, what a great answer. Education, the education access. We need to bet on a training of public civil servants at any level, if it's law enforcement, prosecutors, judges. We need to continue betting on that. And if we examine today how this is in terms of performance, and I mean judges, prosecutors, law enforcement, with all of the things they are lacking, without a doubt, I know that the judges are at a better level than the other two actors. And this is to be a bet on time and obligation by NOM to bet on their training and education. Of course, the judges' education is very different as well. Let's say a judge who is in a jurisdiction with very little budget and they're fighting for the budget, than to that of a federal judge. So these are two completely different worlds, because this is the one that is going to really transform justice into a public service idea by civil servants. And this is the one that will provide the citizens with further tools so they can understand the dark world that they are approaching. That's access one. Access two, accompaniment, as we were saying. So long as we will not simplify and change our legal judicial world, we are going then to still miss an area at the justice institutions to help the citizens step by step. We have the public defender officers, and that's the only way in which we can help the common citizen. Then it's to go through those labyrinths, how they have to do this, what the best options for them are, and with no business or private intermediate purposes, because then we're going to somewhere else. This is what we call, that's why we have the problem of pseudo lawyers, but we have to develop these assistance and accompaniment topics. Something has been developed for the criminal aspect of justice, but we're still missing a lot of things. A third one, and that's the one you were mentioning, Irene, something I learned at some judiciaries in a recent study that I was able to conduct with Mexico Evalúa in terms of information. It's that some have developed specific areas to detect windows of opportunity, and when there is a possibility to have a program with children at schools in which judges are going to be paying them a visit to explain to them what their role is, or to open a communication space on social media up as to make a specific court work known. So we have to be thinking about the constant enhancement and in the opportunity to do new things, and above all to approach the citizens. I think this is pivotal. Otherwise, if there is not someone who is there to do this, anyone is sitting their own way. And the judges have such workload that you can't ask them to think about a better access to worlds for the citizens who are approaching them, because they have queues for the cases they have to solve. So to have within the government structures with the justice institutions to have approach proposals and proposals for reflection with dissemination programs, and there is a lot to do here. And finally, the communication aspect. I think that we've thought very badly in terms of communication for justice institutions that must not have social communication errors as if they were public administration institutions in which we have newsletters of what they were day to day. These are useless, and justice institutions, so our way to understand them are hierarchical because of an internal organization matter. But from the point of view of contact with your public, they have to be very open, very horizontal, and they should have communication ways which are completely different. Maybe the academia, maybe the organizations can help, like some kind of intermediary, to achieve this contact that is to be different, which is not bureaucratic and far away. This is what we have to make known. We have to make everything known, because sometimes everything is not understandable. And then we go to the last axis, which is technology, and which is cross to all others, but it can help a lot for that different contact. Thank you. Thank you, Hugo. I do believe that all of the justice system institutions should have their innovation areas devoted completely to that. We should not leave aside the relevance of the collaboration with civil society organizations, CSOs, and even with these areas, could focus on solving problems of the technological systems that are used internally instead of conducting the necessary innovations. Something we did was that the Federal State of Hidalgo's public Attorney General's office, we had women who were raising complaints about gender violence, and then the process was left midway. So this is a problem of our vital time for cases of violence that can start to be tackled before they scale up. And what we're missing is for women to understand how the process will be and how the participation at the different stages of the process will be. And then we created a brochure for them to know how the criminal process is, what the participation at the different stages of the process was, with a very accessible language for them to understand what they could request the authorities. Another important problem we have in the country is that we have a very bad understanding of the criminal system. If there is no imprisonment, then the victims feel that there was no justice made, and that does not mean that the system failed. And this type of things that could seem simple, we should identify these areas of opportunities at all times. And this is an urgent study. These studies, but sometimes having a WhatsApp line, have a brochure would be more useful than other innovations, so that can turn out to be very costful. Thomas, now we can go to your work. Could you tell us what are good practices for you, not just to consider the streamlining of justice, but for it to be sustainable? The main problem with the technological innovations is that if they are not properly planned, they can be a waste of investment for programmers, and then we have no follow-up for the platform, and then this ends up being a waste of a public resources. So what have you seen in these years that has worked out as in order for us to have streamlining of the system in the long term? One first point, which does not necessarily involve technology, and the second one about technology. The first one, innovation of processes and ways to work. to connect this with what Hugo mentioned, effectively, this has to be disaggregated. We do not have this huge systemic thing. This does not work. And again, I think that this has to start from the fact that we have public service problems. And the first point here is that this problem of people should permit to the institution, so either a public prosecution office, attorney general's office. They do not know what they are working. They cannot tell you exactly in the end what the problem of the society that they are dealing with is. They apply processes, legal norms, and they work a lot. And oftentimes they can't tell you, I am doing this because it's going to help the citizens in such a way, and this may look easy, and then this has to permeate in all of the institution in what they're doing for the people. So this permeates in their working culture, and some we have conducted with the police, and these are important for the administration of justice. We are working with the city of Morelia police in the federal state of Michoacan, and the topic is problem solving focused to a police, which is an American method. The police are going to be using data to disaggregate preventive measures that are going to involve the community, both the community and the police, and also businesses. But they had resources when they were doing they weren't doing anything and anything. So we went to the police and we were like, okay, let's work differently. We started working with authorities. Okay, what's your main problem? What's your problem? Well, people here, they complain a lot because of cars being robbed. So how many did you have before? Well, I don't know. So the police wakes up every day and they were doing things, and they do not really know what the concerns of people were and to which extent. So the work with them was to reach out to them and make them understand and tell them, okay, your goal then is to decrease this. And they were like, yes. And how much can you decrease? And they're going to establish their own goals. And once we have not even the heads, we can start to move the system to develop innovation, because we are working together towards the same goal. So we have I have gone 28 times to the police of Morelia in the last year, and we have told them that we're going to be working on the problems of on their problems, which are the problems of the citizens, and we're going to be developing things to move towards the main direction, and then we're going to have the protocols. So the first way of what I have seen is whether we can work with the people at the front line. We can work with them for them to understand what the public service mission is, to connect the micro to the macro. And once this is known and clarified with the superiors, those are their goals, and not how many hours of patrolling they have had, what's the service provided to the citizens. So then we're going to have a lot of innovation so that it can be created from people themselves, and which are going to be permitted because they come from them, because this is working, and because this works for the citizens. I think that this is the way at the micro level for every institution, and I think that technology can only work if it draws on this. If in the end technology does not come from something from someone who decided that this was going to improve process, because then we will have a bottleneck in the end when people use this. Well, the work is going to be better done, and I think that this is going to create internal pressures for technology to be maintained. These platforms have been changed because they have been isolated with for people at the head, and they have gone away with administration. So it's not for everyday's work because people do not understand what's the use of this. So that's what I could say. Thank you very much, Thomas. Now we will move to the Q&A session. we don't have questions from the public, so we can take these minutes for our last reflections. I think that it was the complexity of the topic was very clear. So I would like to, that regardless of complexity, for your last remarks to be some kind of light of hope. Because if we only stop at the complexity of the things, it's going to be a little bit difficult, regardless of complexity of stakeholders, of the excessive formalism, and all the processes for which we would need to have this streamlining. What can we keep to or use to motivate people's engagement from the civil society, attorneys, engineers, the academia, so to end up on a more positive tone? Here you go, the floor is yours. This is what I was fearing. Actually, if someone asked me, Hugo, in such a delicate, a sensitive topic as the streamlining of access to justice, what would you do? The first thing I would think is to look for people like you, Irene, and ask, where are you working on? And I know that it's not valid because I am making the question back to you, but this is what I would do, because you are the ones who are working on specific things in terms of access to justice. I would, this is going to be some kind of juggling of academic juggling here. But first of all, I would, since I work all the time on most time in justice topics, always with this, how can I say this, these specific principles, which was mentioned clearly by Thomas, we have to know that justice is a public service. So we're going to name the justices, whether this bill, maybe just the lecture I teach my students, we have to be convinced that justice is a public service. And two, and Thomas also said this, I would say this it in a different way. The justice is of everyone, is not from the authorities, is not of justices, is not of prosecutors. Before them, the justice is ours. The justice is something that we need to make ours. And if we take it, we're going to start think it differently, because we have to do this, think it differently. In cultural terms, this came as part of the government functions that an authority was. We have seen justice like that, dark world, which is imposed, which is difficult. So I better not approach it. If we change that, if we consider this to be a natural consequence of the democratic life, justice is ours, and we have to look for it at all times in all of our interaction spaces, some which are very formal and other are less formal, but it has to be present at all times, and we have to think about this all the time. So that's why I was going to be making here some kind of academic juggling, but you know, we have to be convinced that we have to be connected with the topic of this. And every time we think about justice, before thinking about big abstractions, generalities, bills, procedures, let's think about, above all, in the access to justice for people. If that's our priority, if we're always thinking about how this can be improved, how, forget about people, how oneself can go to a court and for it to be easier, to be expeditious, and I hope a very efficient public service. If we always consider this to be a need of our social life, I think that we can contribute with something, with you know, some tiny grains of assistance. And something that I said before in my two previous interventions, we have to disaggregate, we have to take specific examples of access to justice, of who, how, when, not just to remain at big abstractions. Like as a reflection, that's what I could tell you, Irene. Thank you very much, Hugo. And yes, I think that it's always important to complement things, but also to show some roots, because if we remain at the complexity, it seems that we are not doing anything. And that's dreadful. But it's important to have some pathways just to, you know, point at them, you know, because as you were saying, this depends a lot on who wants to take this. I think that we should do this ever more a topic of everyone. We cannot have always the same people, the same organizations working on it. And if there's a problem that affects us all, and I know that this may come as a joke, but if the youth that devoted a third of the time they devote to their TikTok videos to change the justice, things would be different. But now, Thomas, your closing remarks in terms of good practices, where you think we could start, your closing remarks for the people interested in the streamlining of access to justice. Up to optimism words, right? Okay, there is optimism, at least at every public defender office or at every public prosecutor office. We always have amazing people. We always have, we speak a lot about corruption and the inefficiency, but you have seen this. There is always a very capable and hardworking people with good values and who endeavor. So this can give us a lot of optimism. And I think that we have to give them further trust. Sometimes they are under the pressure of hierarchy. They do not have the chance for the good ideas to permeate. So that's the optimism is that they are there. They are within the systems. So they are outside in civil society organizations and societies. So I think that the first level of optimism on which we have to start building, how can we give more voice to these people for their ideas to be implemented? And the second, which concerns technology, is that technology is democratizing again. We are having many things coming. Access during the pandemic has helped in this, and this has been democratized. The new technological direction allows for the strengthening of access for, as Hugo was saying, for the people who need it the most. And these two elements, I think that can give us optimism in terms of where we can go, so we can really have an actual access to justice in Mexico. Thank you very much, Thomas, and I want to thank you both for such an interesting talk. It's always a pleasure to meet you again. I want to thank Mexico the Friedrich Haumann Foundation for such an important forum. I think this is a pivotal topic. Of course, our justice system has many problems, but innovation and what technologies do, good practices, and what can be done with streamlining. I think that in short term, we could come out of the big crisis of the justice systems. And I want to invite you to follow with us. We have another interesting panel, and I want to thank you for your time in this space. And if you want to have a good practice, pay attention to denuncia.org so you can see how to raise a complaint against the crime. And thank you for having been with us. Thank you very much and have a great day, everyone. Thank you, Irene.
Muchísimas gracias. Pues muy interesantes todas las mesas que se han dado.
Thank you. All the panels that we have had have been very interesting so far in the second International Forum on Justice Innovation, organized by Mexico Evalúa and Foundation Frederick Naumann.
De género y grupos en condiciones de
Right now, we will have the panel Gender and Groups in Vulnerability Conditions to Understand Inclusive Justice. We have Alejandra Nuño as facilitator. She comes from the University Center for Dignity and Justice Francisco Suarez. Wendy Jarquín Orozco from the Electoral Judicial School of the Electoral Court of the Judiciary. José Rafael Grijalva Eternot from the National Institute of Criminal Sciences.
De la Fundación Yo También. Y Gloria
from Foundation Yo También, and Gloria Manzotti, Regional Advisor for the Rule of Law, Justice, Security, and Human Rights from the United Nations Development Program.
Muchas gracias.
Now I will give the floor to Alejandra. Thank you very much. Welcome to this 16th panel. This panel of the last day from the Second International Forum on Justice Innovation. I am very glad to be here. It is a privilege for me to be facilitating this panel, which is related to the discussion, to other discussions. The other panels have also mentioned and have been reflecting on the relevance of why we need to have, besides the systems that bring justice in a country with really high levels of impunity and high problems in terms of just the administration of justice, why is it additionally important to consider certain sectors that are in a situation of greater vulnerability and exclusion in many countries, but without a question, Mexico is not an exception. I am very glad to have Katia, Wendy, Jose, and Gloria in this panel. And with no further comments, because the idea is that we listen to the experts in this space, I would like to start with the explanation of the dynamics that we're going to have in this panel. We're going to have two questions. The first one is for our panelists to create some reflections in 7 minutes, and then we will have a second question for which I would ask you to give us additional ideas in 4 minutes. I would like to introduce the first person that is going to be with us, and then I would start with the trigger question. Katia de Artis, she is a reporter, and she writes on the rights of people with disabilities. She has been in different media, and she founded Comunicación para la Inclusión, a civil society organization that is a nonprofit organization that works for people with disabilities. We need to talk about intersectionalities. We need to remember the multiple discrimination that we still have and that many of these people have in Mexico. Katia is currently co-founder of Yo También, Discapacidad, and it's the only 100% accessible communication media that talks about accessibility and inclusion. She was also advisor of CONAPRED, the National Council to Avoid Discrimination, UNICEF Mexico, and she is associate of Libre Acceso ACE and advisor of CIPINA. I have followed her, and I had never had the opportunity of being with Katia in a panel, so I would start asking you, why do you consider that it's necessary to adopt a gender approach that is intersectional, cross-sectional for justice, so that we can create an inclusive system. Thank you very much for your participation. We have 7 minutes. Thank you very much, Alejandra. I would like to greet everyone who are here and the people who are seeing us. I would like to start with some figures, because we usually believe that people with disabilities are just a few of them and they are somewhere else. We're talking about 15% of the world's population. We had very interesting figures. 16.5% of the population in Mexico has a disability. We are talking about 20 million people that if we multiply it by a family from INEGI, 80 million people in Mexico will live with someone with disability in our houses. And these are people that usually are denied the rights to access everything, including justice. We have very few disaggregated data of what happens with these people with disabilities and access to justice, because we usually think of visible disabilities and not invisible disabilities. We think about a person with a motor in a disability, someone who is in a wheelchair, but we do not think of those people who are dealing with the police and have a greater incidence with these things, or are in prison, because based on data from the US or the UK who are taking them into account, these are people with intellectual disabilities or with psychosocial disabilities, or people who cannot hear, and that when facing the police and they start moving their hands because they are trying to communicate, the first reaction of the police officers is to handcuff them or to try to put them down, because we're saying that there's not a good training for the law enforcement. We do not talk about the accessibility of this justice chain. So from the proper training of the police officers, the public prosecutors, the physical access to the places where they can arrive and present a complaint. For instance, if you are deaf and you need a sign language interpreter that helps you to establish your claim, it's very unlikely that you get them quickly, and also that it's a certified interpreter in justice, because there are only 30 interpreters that are certified in these matters in the whole country, and this is really harsh. And also a certified interpreter that has a gender perspective. For instance, if you are a woman that is a victim of violence, we know that there are more women and girls that face problems and violence issues, up to 10 times more than women without disabilities. And this is information from the United Nations. So this is wrong wherever we see it. The United Nations in August 2020 released a document that I think is very important to recommend, which is called International Principles and Directives for Access to Justice for Disabled People. And the rapporteur for people with disabilities, Catalina de Bandas, who is no longer there, and we have right now another person, but Catalina de Bandas did some great work. The International Disability Alliance is an umbrella organization that represents all people with disabilities in the world. They have these 10 principles, and if we read them, they may seem obvious, but the truth is that in disability, when talking about disabilities, nothing is obvious. They say that the facilities and services should have universal access. People should be able to enter to guarantee equality and access to justice for people with disabilities. People with disabilities have the right to have access to right procedures, and this is something that we need to socialize. Despite having them in our legislations, very few people know about this. And I have a lawyer that works here in Mexico City, and she documents that she does it with the court in Mexico City to accompany in their procedures the people with disabilities that require it, in order to do these adjustments in the procedures that sometimes are as simple as making the judge open to the explanation of that they need to explain the people with the person with disabilities what they are being accused of, because there is something that is very common. In Mexico, usually people with disabilities are denied their judicial capability. And that's a really big issue. The Commission on the Rights of People with Disabilities that is part of our Constitution after the historical reform from the first article in the Constitution says that all people with disabilities have judicial capability. We need to find how to support them so that they can be supported. And they are usually denied access to this. So we consider that a blind person cannot be a witness, and or a deaf person cannot be witness as well, or a person with intellectual capability, disability, even if they were raped, they are told that it was their fault, for instance. So they need to have the right to have access to all information, and that is also something that they are denied because they don't have access. And we know that legal language is very difficult to understand for anyone, let alone for disabled people. So we need to have this in easy reading, for instance, in Braille, in the different types. And every time we mention this, it seems as if we were speaking Japanese. So there are different types of procedures, and we need to do different programs of sensitization of this information of the people with disabilities and the whole chain of justice. And we need to have surveillance mechanisms that are solid and efficient from the civil society organizations, because we need to remember that this Commission for the Rights of People with Disabilities in Mexico proposed to the world, thanks to Gilberto Rincón Gallardo in the UN. It's the convention, the most recent, the most avant-garde. And I say that if we apply this convention, since it's so wide, because people with disabilities are such an heterogeneous group, because we have people with visual, motor, neurodivergent disabilities, a lot of disabilities, we are opening the door not only to them, but all the people, actually. When we make a door that is large enough, everyone can fit in. So we should do that more. They have access to free legal advice. I think in this regard, Mexico is doing a good job through the public defenders, and they have 32 advisors in these disability issues, and they are doing a good job. But I think that we really need more. Obviously, we need gender perspective, but we need this perspective of disability as well, and we need to establish how people may have access to justice every day. I would just leave it with this overview in general. In Mexico, interesting things are happening, such as the case of Arturo Medina, who is the first person that the Mexican government offered a public apology to. They need to repair the damage. I think it was a month ago. It was a problem with the state, a litigation after 4 years. This was 10 years ago. Arturo is a person with psychosocial and intellectual disability who was accused of stealing a car when he cannot drive. And because of this disability, he was denied the possibility of receive a defense. So this is a clear effect of how we still see people with disabilities as subjects of treatment instead of subjects of justice. He was in prison for 4 years. Then he was able to go out, and then the Commission of Human Rights recognized that he received a lot of violations of his human rights. And I think right now things are changing, and I think I ran out of time. Thank you very much, Katia. And I think it's very important to see the lack of statistics, but also to understand that Mexico is part of the international convention. This convention that also speaks about inclusion regarding gender since 2008, and Mexico had presented a document on this topic of the legal capacity. And in Mexico, we also have a general law for the inclusion of people with disabilities since 2011. And they are also trying to cross it with disability and gender in other suspicious categories. So thank you very much for reminding us how important it is that we can also see other situations and other categories that may make access to justice for people even more complex. Now I would ask Jose Grijalva to take the floor. Jose Rafael Grijalva Eternot. He has a degree in law by UNAM. He has studies in sociology by the Metropolitan Autonomous University. He is a professor in international law by Universidad Complutense de Madrid. Jose has published different papers nationally and internationally. He is a researcher in the UN. He has been the director of the School of Law and the University of Claustro de San Juana, and he has also worked in human rights with the current Commission of Human Rights in Mexico City. He is also a member of the autonomous group on forced disappearance in Coahuila, and he has also collaborated with Universidad Iberoamericana. He is right now professor of INACIPE as associate researcher of the faculty of the School of Bioethics, and he is also in the group Checks and Balances, and he also works in public policies and human rights. Thank you very much, Alejandra. It's a pleasure for me to see you and to share the space with Katia, Gloria, and Wendy. And I think that they will mention more interesting elements than me, but I think that a way of addressing this question, what is the importance of the gender approach related to justice? We may analyze this from a historical perspective, also from a perspective where we can understand that this idea of human rights and gender cannot be divided, and also the general model of human rights. I think that these three elements can be joined in a very interesting way and allows to understand and say this thing that in another context, an Italian professor said that human rights have a certain type of original sin. I think that this liberal model of human rights based on gender is related to this original sin. And I think that if we analyze the French Revolution as the start point of this liberal movement, we may analyze different moments. The French Revolution is a moment that had a great impact, not only because of the flags that they had, but the social groups that they included in the movement. It's a movement that included the workers, the farmers, and they also included women. So in the assembly of the revolutionaries, there were different declarations where they included specific chapters of rights for workers, rights for farmers, and rights for women. But they were changing in other versions, and we reached a final declaration, which we call the French Declaration of the Rights of the Man and the Citizen. So we have two specific categories that are established from this start of the liberal state. Rights, yes, but for men. Rights, yes, but for citizens and men. Maybe I would say that this is a more objective or real name of this declaration would have been the Declaration of Rights for the white and men who owned something, and those who didn't fit there, they would be left behind. So some of the things that were mentioned here and why it was said that the rights of women that were contemplated initially, they didn't have to be there, and they said because it's generating a delicate constitution. And why is it delicate? Because the feminist revolutionary movement was being used by the Black community that was in France and by children. So it's a movement that is using a lot of things. So they said that it was delicate and it was very tender, and there is a fragile reasoning because they are intellectually inferior. So this liberal movement, in a model of these liberal women, it was not related to this Republican women model that we have seen in literature, in culture. These women that, as long as they are not mothers, they are just the lovers of men. But when they become mothers, they become the caretakers of the children and of the men in order to turn them into good citizens. So that's the liberalism that we could see there. And that's why Oli, who had belonged to this group and who had established this chapter of women's rights, when he published this chapter of the rights of French women, he received as a prize that he went to the guillotine. So this means that this part was taken out because of this. And it's necessary to adopt a gender approach to establish justice models that are inclusive and proper. First of all, because we have a historical debt with the revolutionary feminism. This is the first thing that we would have to highlight, because this revolutionary feminism was not only given in France, but it has been part of many social movements. Why? Because this debt comes from a series of vulnerabilities that women have suffered historically. When I'm in class, I do an exercise in which I do a role play. And in this role play, I put volunteers in different roles. Someone is going to be a business person from Monterrey. Someone else is going to be a foreigner. Someone else is going to be an indigenous person. Everyone has a role, and then I give them different situations and different circumstances. I say, do you have access to internet? Do you have running water? You finish high school? Do you have a major? And every time they say yes or no, they need to give a step ahead or a step back. And the idea is that if we have this liberal movement of rights would have been inclusive, all people should be giving a step ahead. And in the end, everyone should be at the same level. But the reality is that this line is very different for everyone. And this shows the distance of the structural inequalities. And in all the exercises that I have done, there is always a white man that owns something at the front, and on the back, we have the opposite. We have a non-white girl that doesn't own anything. So this means that this original scene, beyond the constitutional reform and beyond the fact that we have created a system that is based on human rights, we have not been able to leave behind this original scene. And why is this approach important? Because this gender approach means that we have a political intention. There is an intentionality in the use of power, because that's what feminists did in France. That's why they were concerned about girls and Black people, of those who don't have power. So it's a political dimension that, as French feminism did it, it recognizes, acknowledges the existence of inequality, of discrimination, and it's active. It's looking for the construction of equitative decisions. That's what I would have to say. Thank you, Jose. To remember where we come from and where we have not been able to go. After centuries of exclusion, we are still seeing, and I was trying to think about the different cases of the different rulings. Half of the rulings are related to severe violations of human rights towards women and girls. We can remember different cases of women that are victims of sexual violence and torture in El Salvador Atenco. Now Dina Ochoa, with vision and gender approach, she is a defender of human rights. And we need to remember these two cases that were very important, and it was because of a case of sexual violence towards a girl, Inés Fernández Ortega and Rosa Antina, they were indigenous in the state of Guerrero. And from that moment, the Supreme Court of the country started thinking about these action protocols for the operators. And the first of them was the protocol to establish justice with a gender approach. So thank you very much for this reminder. And with this, I will introduce our third speaker, Wendy. She has a major in law in the University in Nicaragua. I will show all my solidarity with Nicaragua, and she has a PhD in law by the University of Castilla de la Mancha. She has different postgraduate degrees. She has different master degrees in the constitutional guarantees from the perspective of the 21st century. She's a specialist in constitutional justice, fundamental rights, and writs of amparo, and also a specialist in different types of law. And she has also been a lecturer in the constitutional part in the Supreme Court in Nicaragua. She's professor in constitutional law in Nicaragua. And from 2009 to 2018, having participated in the organization of different congresses and seminars in constitutional law, she has also participated in different research projects. She has given different conferences. And currently she is a professor and researcher from the electoral justice from the Electoral Court. Wendy, the same question for you, and thank you very much for being with us today.
Thank you, Alejandro, for me. It's an honor to share this panel with Gloria Gatia, with you and Jose Francisco. I'm going to focus, to approach my question from the electoral justice perspective, which is the topic on which I am working. And from this very little known perspective, how a constitutional court that protects, therefore, human rights and an institution that is responsible for eliminating excluding paradigms for the citizens in a democracy. And I'm speaking here not just about women, but also indigenous people, homeless people, people in prisons, disabled people who have been excluded from the exercise of their political rights. And as we were saying, and Jose Francisco was saying, this starts from inequalities. It's important to have this attentive focus and to use a different lens when we assess, when we study cases involving vulnerable groups. Because this approach will allow us to identify and eradicate stereotypes that sometimes we have considered as standardized in our culture and that prevent us from reaching a substantive equality in reality. And this approach is also interesting, and it's important to speak about the human rights approach and the differential approach that allows us to identify and acknowledge the differences of gender, ethnicity, age, and its implications to achieve a transformation and as an elimination of exclusion and discrimination, and of course with a disabled perspective and the inclusion perspective. In terms of gender, the Electoral Tribunal has been building from the moment these approaches are incorporated a jurisprudential line, which is very rich in inclusion matters. For instance, we could name the decision Ante Juanitas of 2011, in which we acted against the resistance of political parties of comply then with the affirmative action of gender quotas when they were proposing women candidates to have to comply with the law. And then we have seen how this has moved forward the integration of representation in lists, proportional integration, affirmative actions. It has been set forth, as it is said in international treaties, that these are not discriminatory. These are measures that are there to act against discrimination, and we are moving towards parity in Mexico, and we have advanced in this way in the governor offices, and also we have a historical decision from which we achieved parity at the Congress, and I hope that this will then be known as the Congress of Women and Men. And this has to become a substantive parity reality. This highlights the fact that sometimes the legislation is unnecessary, but ends up being insufficient to achieve inclusion. And for this, we need a further participation of our authorities and of the citizens. And in the case of the electoral authorities, we are missing this open approach acting with regards to substantive integration. Today, we could think we have party integration at the chambers of deputies, and there is no more to do. This is to fool ourselves with a false idea of equality, and maybe maybe this resistance is not as before, but there are barriers that we have to overcome to achieve the substantive parity. And so we find that people we have gotten to political positions, but not leadership positions. We're still getting the chair, but not the place. And then we have this political violence phenomenon against women, which is not a new phenomenon. It has existed from the fight for women's right to vote. And this is delimited. We know that last year in Mexico, legislative reform was approved, introducing the classification of political violence against women that sets forth clearly that this violence can go against men. The difference is they are not attacked because they are men, which is the case of women. Prior to this reform, the Electoral Tribunal had already been issuing jurisprudence here, legal cases, because in Mexico, we have treaties in these matters against violence against women. And we had an electoral sanction. And then people in the position being punished for this, well, we took off many pieces of advertisement with sexist messages, and we considered the cancellation of elections because of the same topic. For the first time, an election would have been annulled in the case of the Atenco municipality. The use of this gender approach and of human rights has adopted measures to facilitate access of women to effective judicial protection. And that's a flexible standard because these new barriers and gender political violence are expressed in other ways. So it's difficult for women to prove that they are being subject to such a situation. And therefore, the evidence system has been changed, and the burden of the proof as well. So we have to show that an act was not because of discrimination. The value assigned to the victims says with testimonial, and also in the best interest of a victim, we have adopted now reputation guarantees to not leave them in a state of insecurity. This is just an outlook of how these approaches are essential so we can really achieve effective access to justice in the electoral field. Thank you very much, Wendy, for giving us such a possible example of the progress in legislative terms and judicial terms, specifically in the electoral field. And we are still missing, right? So how this lack of leadership or crystal floors, roofs are still reflected in matter attitudes of political parties, because they want to leave the most remote municipalities to women, and it seems the party is still not important, and the differentiated approach, the gender and human rights approach that permeates ever more to into the Mexican legislation, but we still don't know how it works. What's a differentiated approach for you, or gender or disabled focus approach is different for people, including judges, to tell us what a differentiated approach is about, and the evidence burden and the assessments that we have for a decision. We have had an activist already. We have had someone from the academia, a judicial servant, and of course, we would need an international servant in this panel. So for me, it's a pleasure to introduce Gloria Manzotti. She has over 17 years of experience of work in the United Nations Development Program at UNDP. She has worked in different Latin American countries. She has worked on several field projects. She has provided assistance to the different UNDP offices, the region government, especially for citizens' access to human rights. She has supported several programs to support and promote citizens' rights, the prevention of conflicts. She has provided counseling and public policies for these topics in different places of Latin American thinking about the justice systems in our region, and of course, including the human rights agenda. Gloria has also combined her academic experience with the public function, and she has also been part of the management team of the airport law enforcement team. She has led the design of the police training institute, and she worked on the rule of law in Argentina. Before having this position, she worked at the UNDP at the Panama office, and she has consolidated strategic alliances by mobilizing resources for new strategies. Evidently, she has actively promoted innovation and the link between the 2030 agenda and the human rights and youth inclusion. She has contributed to create new knowledge and tools for action in terms of gender and rule of law. So it's a real pleasure for us, who is a regional counseling of the UNDP for Latin America and the Caribbean office, to be with us today. The floor is yours, Gloria. Thank you very much, Alejandro, for your moderation. I know that the minutes are starting to be counted, but I would like to take this opportunity to thank, and for me, it's to thank you, and for me, it's a pleasure to share this panel with Jose Francisco and Wendy and Katia. For us, it's a pleasure as the UNDP for Latin America and the Caribbean, but I also want to thank the UNDP of Mexico who are with us today on the platform. What better than to contribute to reflections? I would like to frame the challenges that we have been faced with, and we have considering that the region has been highly impacted by the COVID-19 crisis, and we were surprised to see this health crisis that became quickly an inclusion crisis, a crisis of rights that showed those structural inequalities and expedited the implementation of those urgent institutional implementations, which we have seen an exacerbation of discriminations, inequalities, and unfortunately the risk of increase of institutional violence. Crisis from the UNDP has a power crisis in terms of governance in this sense, and also crisis consists an opportunity to rearrange institutions of people and the relations between them and between people themselves, and also from the justice perspective as well as access to justice, how justice is an enabler for the generation of opportunities. Those who came before highlighted urgent challenges for specific populations. And from here, I want to tell you that the UNDP, following the Pathfinder Working Group globally, we started to develop that series of conversations and research, and I'm going to tell you about this in a little bit, but how we could achieve this ambition of justice for everyone. That's justice that really engages in achieving or in not leaving any border behind. That's the 2030 Agenda motto. But for this agenda, we have a specific goal about transparent institutions with quality responses and efficiency. That's SDG 16, and we have a specific goal oriented to or aiming at giving an answer there that we have seen in our region, and that is a part of the problem. Either we incorporate this dimension to the analysis, or we won't be able to transcend neither the realities we have nor the public service model that we've got. Again, how can we reorient this by focusing on users, on people? Because that's the only way so we can think again about those services and we can ensure rights. It's the only way we have found to face digitalization and innovation processes that are arriving to the Latin American justice systems, and how are we going to make them accessible to all. That's the conversation that we are having. The COVID-19 crisis, well, during this time we developed a report based on the region's experiences that I'm going to leave at your disposal, which is called Innovations and Urgent Transformation Towards an Inclusive Justice, a possible translation. And we started to collect the experiences and the first measures that the justice systems of Latin America and the Caribbean were taking to understand how we can have peer-to-peer support, and we are going to find a myriad here of experiences of access to justice, how we can take it out of the desk and take it to the communities, and how we are going to find tools so we can face or experience-based tools and experience and recommendations-based tools, as was the case of digitalization, when we started to have access to justice services, but as users are through platforms who have been to virtual hearings. But how can we do this in a arena where we still have the challenge of the technology access gap? And in here, you will be able to find different experiences. And we also devoted some good time to think about gender. We immediately addressed the prevention and assistance services of gender-based violence in the health crisis context. And in such a context, women were the main victims, because lockdown led to scenarios in which we had the perpetrator at home 24/7. I'm going to say this very quickly, but in those activations, I recommend the experiences and to go back to get in touch with the spotlight experiences in different countries. Protocols and mechanisms have been adopted to guarantee access to justice, coverage, and due process as well. So we can have protection measures. But it was also interesting to see that whether we think about access to justice as the social inclusion enabler, we would not only need to address issues from the criminal justice perspective. How can we create access, equal access and equal opportunities for women from another jurisdiction, that is by providing justice access tools? I loved Wendy, how she shared the perspective of the electoral justice and its challenges. We also have challenges here, and I can tell you and recommend that you follow closely the Chilean experience just in political violence, and not just against women, but the conversation of a new institutional architecture that is being built, and also the Honduran experience and that of Mexico. Going back to the creation of opportunities, and I'm running out of time right now, but it was the need to rethink services. We don't need a huge resource investments. When we translated the processes that did not need an attorney into indigenous languages, we have seen how the justice systems open the possibility for indigenous people to have access to land ownership, divorce. The opportunities we have are huge. And as I have run out of time, I want to close with the next message. This is possible as well if we redefine what we understand as a gender in the justice sector, because if we continue considering the amount of judges in Latin America who are part of the Supreme Court, if we continue to see challenges as, if you consider the challenges for public defense in Brazil, the main percentage of women as requesting for assistance are Afro-descendant young women. The system has as in their alpha white men. And well, this is just one example of many. And I'm going to stop here. Thank you very much, Gloria, for reminding us how the pandemic boosted the inequalities that we all knew, and it's created further conflicts and violence indices, violence against women and girls who have suffered it during these times, and how I think that it's really important, not just what you were saying about rethinking about the services and thinking about access to justice as an enabler of equality, and how we're even thinking about our social justice systems. I'm going to take this idea with me in gender violence cases in Mexico, and quite surely in all of the Latin American countries. Usually the lady goes to a family court to raise a complaint or to request for divorce, but she also goes to the criminal court, or maybe she is still looking for the custody of her children, and then she goes to the criminal court to raise a complaint against the violence, and maybe then she goes to another court to ask or request for some type of assistance. As you were saying, it's very important to think again about services in different places for them to be more comprehensive and effective for women and all those people who have conditions that disables them access to have access to justice, or makes it even more difficult. And now we're going to the second part, again in the same order as we started. I would like to us to think about why we must think in gender terms, but and Jose was mentioning this. We have some barriers that with which some groups are faced in terms of access to justice or due process, and how innovations could help build a more inclusive continent, like Gloria mentioned. Katia, the floor is yours. First of all, I want to say that I am very happy. Thank you very much. First of all, I would like to say that I forgot to describe myself. I think I'm always doing this when I'm in a panel like this. We forget that a person, like a blind person, can be watching, and it's important to say that I am a middle-aged woman with hair all the way out down to my shoulders. I am having some, I'm using some red glasses, and I have a Mafalda, a statue of Mafalda, of the Mafalda character, because I am her fan, and also to emphasize the fact that we need accessibility a lot. This is one of the main barriers to justice and for everyone. Usually we forget accessibility, right? So this is just a tiny detail, and I think that we do not have an interpreter in sign language, so we do not have any signing person who could have had access to these reflection. One of the main barriers we have, sometimes they even have to look for protection. Even in the context of COVID, we were able to have information in the Mexican sign language for emergency situations. So one of the main challenges is intersectoriality, right? Because you were saying this, I think it's very important to have these guides for access to justice by the Supreme Court, and they're going through them. But then we had the LGBT community, indigenous people, and they don't think that they can have a trans indigenous woman, trans indigenous disabled woman. And we have to think about universal design. What so we are just one. Well, first of all, we are not things, right? We have different conditions and characteristics, and I mean every person. I want to speak about how technology can be level or something that is going to deepen the gap if we do not consider this based on a universal base, because now that we're speaking about injustice, and I think that this is great, if we do not do this based on a universal design, and only 1% of web pages are made like this, either for intellectually disabled people or blind people, that is like closing the doors on their faces. You cannot come here, and that's it. It's important to continue fighting against a culture that constantly discriminates. As Wendy said, we have these standardized stereotypes, right? That people with women, that disabled people are weak, and we are cute, and as we were saying, we still have a lot of people who continue to think in this way, and this should not be the case anymore. The Convention on the Human Rights of the Disabled People, it's been years that it was ratified in Mexico. However, it remains unknown for many matters and many other things. So I know that cultural changes take generations and most time, because they have this has to come from education. They learn to live together, and they know that but children have no problems. Those who have problems, to consider inclusion and see a person, a disabled people, or a successful woman. It's the adults, those of us who have this normalized stereotypes. I would say this. We have to work more on culture, and we have to continue working on accessibility, because it's a right that opens the door to the others' information, and also to for them to be able to have to work, to be everywhere. And I think that we have to try to eliminate this. This is one of the main barriers when we speak about women. Here I was saying just some very interesting report of a decade of their investigation lines. I interviewed one of their lawyers with regards to the topic of disabled people. It's amazing how up to now disabled women continue to be denied access to sexual and reproductive health services because they should not be mothers, or they are object to forced sterilization, right? Or abortions. So this is one abuse after another. So thank you. Thank you very much for those reflections, Katia. Jose, please. Yes, thank you, Alejandra. If we focus on justice, on the institutional justice, that's the one provided by courts and the prosecutor's offices, I would find three. I would like to speak about those minutes here that we still have. I see an epistemological barrier. How we are understanding justice. What do we understand as a justice, right? At different times, different organizations, the World Justice Project, justice is understood as something that is far from the citizens. Here we have an epistemological understanding of justice. It's not something that should be close to the citizen. This is not close to people. This is justice of intermediaries, secrecy, technical language. That's a big barrier. How can we jump over this? It's to have open justice, not just open in terms of data, which is the main point, but open to dialogue. We have this initial figure, which is not even well regulated in Mexico, and even though this is being set back, open in terms of a language, but a broad language, not just a verbal language. Of course, I celebrate that there are decisions by the judges with a language for children. I had to go for an amparo, and I celebrated that this decision by the judge had inclusive language for my daughter. But that's step one. I have to go from a semantic to a semiotic of justice, in which verbal language is included, but also the symbolic language, structural language. That would be the main barrier that I find about which we could speak a lot. Another one is a technical barrier. Justice focused on judges, and it is very evident in which we are requesting for numbers to the justice, to our justice operators. How many are you detaining? How many are you going to imprison? And we focus on this, but not on the person without, again, that tool. This would be a personalist, that is a human-centered and a human dignity-centered approach, and it has to be focused on the characteristics and conditions. And forget that justice is blindfolded, and it has huge eyes going through every gap, through every difference, to allow for the establishment of a more technical model of justice. And I have always spoken about this anti-formalism or ethical formalism. The judges, for the judges to have some kind of control, formality, just like they do for constitutionality. And those which are not important, they go aside. And finally, the operational way. We think open justice is, I'm going to open the doors for the citizens to go there. And also open citizens implies this open door for both parties. So for the citizens to go there, and also for the judges to go out, for they're going to have a social impact, an encounter with the context, and to have some kind of pilgrim justice in those cases where it's necessary, given the vulnerabilities and the specific conditions, for the justices to be a pilgrim to go meet the citizens and the vulnerable populations. The Roto Yaka case, which became very famous, it was not able to be solved because community could not go to the city of Oaxaca over and over. Why the court cannot go to the region in such an important case and with such peculiar characteristics? Those would be the three barriers that I would propose. So thank you, Jose. This is very interesting. Wendy? Thank you again. What has already been said. I'm going to focus also, as Katia said, on disabled people and the barriers that they have to face to have access to justice. As she said, we have the Convention on the Rights of the Disabled People, in which very evolving. We have this evolution of the concept of disability that we have today as a disability, which is no longer a disease of the person. It's not a specific characteristic of an individual. It's a social construction problem of barriers that they are faced with. And I mean this group, either environmental, cultural, even a norm barriers, product of this new conception. And this is that we have to assume a social responsibility, and we have to accommodate this as necessary for the disabled people can fully participate in all of the settings, including that of justice. And in the case of the electoral justice, the Electoral Tribunal has issued a criteria for which they make it clear that electoral authorities have to adopt measures guaranteeing effective access of people with disabilities to justice. What does this mean? Well, this means that we have to remove all of these contention dams that they encounter when they get to they approach justice. This means conditioning space, but also accompanying them throughout the process. At the Electoral Tribunal, we are still missing to have a public defense office, and this is set forth in that it's issued with this criteria by the Electoral Tribunal. And also we are missing the issuance of decisions in accessible formats and have those reasonable conditions so people can have access to information. And Katia was already speaking about this. We have to make this conditioning of this information. We had a case at the Electoral Tribunal. This was a publicity split, and we were denouncing anticipated statements in the campaign. So we found that there were no anticipated facts, but it was found out that those publicity spots, so sometimes we are not sensitive to them. We had no accessibility for people, for disabled people, for hearing impaired people could have access to them. And then we had the opportunity for the chamber to invite and encourage political parties to include this accessibility in their publicity spots. And we had to include sign languages, and I mentioned this at the school. We have this barrier, having no translation into sign language, where a hearing impaired person can have access to our sessions, something that has been established in the Electoral Tribunal. Now, with regards to the accessible notification, this has worked as well because of a case that a person had. We did not focus, we did not go to this. I thought that this case was a room for more for the political parties to include disabled people within and for the candidacies, and then we move in this sense. But from this moment, with this impaired person, people with this disability, they will be able to decide whether the clerk is going to read a copy of the sentence and can have a copy in a Braille writing. As Katia was saying, we have also we have also to acknowledge, and this is an obligation by Mexico, and the convention is mentioning it for the fulfilling thereof. The judiciary has been working on this. It has not been the case of the electoral tribunal, but I'm going to close with a case. A person in virtual state, they needed their ID to have access to their benefits. Then his son go to look for help, for assistance, to have access to social security. And there is an article established by of law that such as that we can whereby we can ask for a public servant to go to the individual's domicile, and then with this formalism that Jose Francisco is mentioning, he said, yes, we have the article, but I don't know if this can be applicable to this case. So I request Councilor to Ina Normative Secretary, yes, said yes, this is applicable. And then we have such a situation, and then we can the servant will have to establish this clearly, precisely the intention of the ID cards holder. What was the purpose? So imagine, ask a person for his will and doubt for the ID. Then this goes to other jurisdictions, and because of the administrative, and it was clear that we have to act as the convention establishes with reasonable adjustments, and we have to be aware that when we do not conduct those adjustments, we are discriminating because of disability. We lack knowledge, awareness raising, and action, not just by the citizens, but also mainly of our authorities. Thank you very much, Wendy. We have no more time. Gloria, your last intervention, please. You're muted. Sure. I was saying I call an urgent call to action from the Secretary of Justice, one of the last bastions of patriarchal institutions, to achieve those effective transformations obtained from public services focused on the person, for assistance and protection of women. Judicial institutions first have to transform themselves, and they have to have an intersectoral, an intergenerational focus. It is not just a gender focused plan, but that reconstruction of the judicial institutionality that incorporates that gender policy within the organization, allowing to permit in a comprehensive way both the public policy of justice and the organization. There is an opportunity here. It's now or never in Latin America. That's the opportunity to conduct this actual transformation in matters of gender, for this not to be an isolated way. So this is one of the main pillars of the judiciary. Of course, we need a cultural, organizational, budget, political, and problems and engagement with concrete measures in the short term, mid and long term. And I want to say something. I invite you to get to know a little bit more about the gender seal of the UNDP for public institutions. While this has been a methodology that is present throughout our region, then we can start to have some experiences in the justice sector. We also have to incorporate in the planning, strategic planning processes of the justice sectors, how we're going to incorporate innovation, how we're going to incorporate this in the definition of the public service, and how we can reflect around access to justice, to have an inclusive justice present in all the national territories that can give us there's evidence of quality, transparency, and efficiency for the citizens. Otherwise, it's going to be very complex for us to have to have that perception, that credibility for the justice. Katia, Jose, Wendy, Gloria, this was an amazing panel. Thank you very much. There are questions from the public. Unfortunately, we have no more time for them, but I'm sure that the organizers will convey them to you. Thank you very much for this space of reflection about what we have done and what's amazing in terms of gender inclusion, but also in terms of other groups and vulnerable groups that need and have a right to justice. Thank you very much, and it was a pleasure to be here.
Muchas gracias a todos los panelistas. Sin duda, importantes reflexiones las que nos quedan
Thank you very
sobre
much
cómo
to all our
innovar para
speakers.
garantizar la
It's
inclusión y
an
reducir las
amazing
brechas.
contribution that you do to
Pueden
guarantee
seguirnos en
inclusion
nuestras
and
redes
reduce
sociales,
gaps.
en
You
nuestro
can
canal
follow
de
us
YouTube
on
de
our
México
social
Evalúa,
media and
así
on
como
our
visitar
YouTube
nuestra
channel
página
Mexico Evalúa, as well as to visit our website
Seguimos con las
www.mexicoevalua.org.
actividades de este segundo Foro Internacional La Innovación en la Justicia, organizado por México Evalúa y la Fundación Friedrich Naumann. Y ahora
This is the
tendremos
second
el
forum
panel
on
de
Justice Innovation
aproximaciones a la
organized by
impunidad,
Mexico Evalúa and
con la
Friedrich Naumann
moderación
Foundation,
de
and then
María
we will
José
have our
Salcedo de la
panel
Fundación Friedrich Naumann,
Approaches to
Juan Antonio
Impunity,
Leclerc Ortega de la Universidad
facilitated
de
by
las
María
Américas
José
de Puebla,
Salcedo by Fundación
del
Friedrich
Centro de
Naumann,
Estudios sobre Impunidad y Justicia y del Índice Global de Impunidad. Cristel
Rosales from
investigadora del
Mexico
Programa de
Evalúa,
Justicia de México
researcher from the
Evalúa,
Justice
y
Program of
Elvin
Mexico
Díaz,
Evalúa, and
presidente
Elvin
del
Díaz,
Instituto de Estudios Comparados en
president
Ciencias
from the
Penales de
Institute of
Guatemala.
Comparative Studies in
Muchas gracias
Criminal
a todos.
Sciences in Guatemala,
Le
as
cedo
well
la
as Juan
palabra
Antonio
a
Leclerc
María José
Ortega from
Salcedo.
University of Puebla. Thank you everyone for being here. Hello everyone, good afternoon who is here with us. I apologize because we started a little bit later than we were scheduled, but it's a great panel that we have today. And as you could hear from our presenter, we have Dr. Juan Antonio Leclerc Ortega, who is an expert in impunity topics by the University of Las Americas in Puebla. It is a great pleasure to have you here. Also, Cristel Rosales, who is a senior researcher from the Project of Justice from Mexico Evalúa. Thank you very much for joining us from Guatemala, from the Comparative Studies in Guatemala. I want to continue with the line of what has been talked about in this forum, which is to approach justice to the population and the people that are being affected, as we all are. I am Maria Jose Salcedo, and I work in the Frederick Naumann Foundation, where we promote the rule of law, because even though impunity is present in all societies, the conditions that foster it establish the need of a robust law, and the effective justice system establish mechanisms through which we can give certainty to society. Victims can know that a case was solved and that might be a compensation. And inefficient justice systems are unable to do a good strategy for solving crimes. The impunity levels that we see show the response level of the justice institution to the different cases. Sometimes we say that those things that we cannot measure or that we cannot assess, we cannot improve them. And it's not that we cannot improve them, it's that we cannot even see them. If we cannot see a problem, it's as if we didn't believe that it exists and that it should be addressed. And that's why it's important to have the topic that we have today in this panel. I want to tell you that each expert is going to have 12 minutes to present their answers to the questions that we have today. First of all, I would like to start with some concept approaches to impunity. What are the exercises to measure them, and especially the innovations that exist to reduce impunity? And then in second place, those factors that stop the status quo of impunity from changing. I mean, the relationship between corruption, impunity, and the role of the institutions regarding impunity. We are going to start then with Dr. Juan Antonio Leclerc Ortega. Welcome, thank you very much. And we will start with your 12 minutes. Thank you very much, Maria Jose. Good afternoon, everyone. It is a great pleasure to greet you. I thank Mexico Evalúa and Naumann Foundation for the opportunity of participating in this second forum of innovation in justice. And it's a great opportunity to exchange experiences and perspective of the reforms for access to justice. It is a great pleasure to be with Elvin and Cristel this afternoon and to exchange our ideas on impunity. To start to solve some of the concerns that we have with these questions, I think that we should establish that the approach to impunity is a certain type of methodological innovation, as well as ways of understanding some public issues with access to justice. I am always surprised to see how this issue has become a specific aspect to understand some of the greatest problems that we have in our countries. I don't think there are other countries in the world that have developed so many approaches for the problem of impunity, and that these approaches have become as well methodological projects or of public policies that are focused on measuring specifically its approach. And I think this is very important, that from the last 5 or 6 years, most of the discussion, the specialized and academic discussions that we have had on security, corruption, violence, and justice were complemented with a very strong discussions on the results, the scope, and the problems that we have with these great levels of impunity. Why has this become so relevant? I think that this is related to 3 aspects. The first one is that from any approach that we take, it doesn't matter what the methodology or the conceptual point of view is, we can see that Mexico is characterized globally by its high levels of impunity. And when we see the analysis in different states of the country, we can see that nationally, impunity levels are very, very high as well. It's very difficult to find cases that are in low levels of impunity. And we can see that this is a complex problem that will make these social consequences even more severe. And these are created by different types of social problems. And I also believe that Mexico is facing a process of pathological innovation in terms of public pathology. All countries face different problems in case of public or political pathologies, such as violence, security, unequal access to justice, and corruption. These are problems that exist unavoidably. The problem is its magnitude, the scope, the extent of time, and of course, the amount of victims that it produces and the way these are giving feedback to each other. And I think that Mexico is having this pathological process where violence, injustice, and corruption and other types of problems that are correlated, we can analyze them and measure them, and we're going to find a very bad performance. But besides being connected, all of them can be related to each other, and we cannot measure impunity by itself, such as violence. We need to analyze it in the way this damage is given in the consequences on each of the areas. And another part in which impunity is so important is because we have institutional traps that are very complicated. And I understand that an institutional trap, we need diagnosis, we need proposals of alternative public policies, and throughout time we have had imposed different trajectories and changes and adjustments to public policies, and with the changes of administration, they do not lead to a change in the trajectory or the magnitude that these phenomena acquire, and they do not improve the situation of the people that are affected. This has taken to try to understand the factor of impunity and to try to conceptualize it. From this perspective as well, we have had different types of studies. Curiously, we have a lot of quantitative studies that are focused on establishing measurements, something that does not necessarily happen in all areas. And given the depth of the topic, we need to reach an agreement. Impunity depends on where you are seeing it from, what phenomenon is it related to, and of course, from systems that give us a narrow or an open definition of it. A narrow definition is if we only identify the complaints versus the rulings, or if we have a result of so much impunity that exists. There are different studies that INVITE uses to measure levels of impunity compared to the number of claims, etc. But the open definition is that articulates more substantial areas, acknowledging that this is a more complex phenomenon that involves safety, security, and even inequality from the social and economical standpoint. And this is unavoidable. There are different ways of approaching this, and we must do different exercises. I think we have three types of approaches. Those that have the direct intention of measuring impunity itself. In the case of the impunity index where I work on, we have that objective. Our objective is to measure impunity, and from an open concept, in a compared way globally and nationally, we have three dimensions: security, safety, and violations, security, justice, and violations to human rights. And we try to measure directly impunity. A second type of studies that have another type of approach, I think that they come specifically from analyzing problems in non-specific areas, as it could be the criminal system, the performance of the violation of the different institutions, and violations to human rights. And we need analysis that are wider in this area And I think that this is what happens with different findings, where we can give a follow-up of the criminal system and they conclude that they need to incorporate a component of impunity that comes from this main study where we see what is happening with the criminal system. These are different approaches with different objectives, and they help us try to understand and have a general approach and generate conclusions on what is happening with impunity. The third approach is that we do not have the intention of studying impunity, but from the conclusions of the study, we necessarily need to include impunity. And I think this is what's happening with the different projects that do not include an indicator or a dimension of impunity, but after including the rule of law in different reports, we can find very interesting conclusions on the consequences of impunity in the cases where there is a weak rule of law, such as the Mexican case. In our case, what we do in the Center of Studies on Impunity and Justice, we try to approach impunity. This is something that we have done since 2014, and we have tried and do it in different countries, trying to study complex issues. There's an additional direction that we have developed, which is the statistical impunity, and this is related to the existence of data. Sometimes we cannot measure impunity regardless of how you want to measure it because of the quality of data and the lack of capabilities for creating statistics or the lack of will to report it, or because we have a lot of hands on this information and there is manipulation. So the index of impunity, we can compare it with up to 69 countries, and Mexico has become one of the top 10. And the thing is that it doesn't matter how we see and how many cases we have, Mexico is still in a place of great impunity, and it highlights programs of different capabilities that are related to a justice system that does not have the capability to guarantee access to justice. In some cases, we may have a better capacity in the security systems, but it doesn't have the best capabilities when guaranteeing the right of safety for people. And this goes along with really high levels of violations to human rights that take us to a level of discussion that is very difficult, and we find a complexity to find solutions. And in the case of the studies in Mexico, what we did from 2016 to 2018, and we are trying to present in the next few years, is a measurement to try to understand in a country with such levels of impunity if there are significant differences among the states. And unfortunately, we found that it's not. The story is very similar, and there are just a few statistical variations that are product of the selected indicators, but we have a story where basically all states have very limited capabilities and therefore high levels of impunity. In some of them, this impunity combined with phenomena such as violence, inequality, and unequal access to justice has been translated in really severe problems at state level. And in others, there is a better situation apparently, but what we have concluded is that despite the fact that some states seem to be better and others worse, the truth is that when something changes in the environment or things start moving, there are no capabilities to react, to prevent violence, and to reduce the index of criminality, as well as to guarantee access to justice. And finally, we have tried to extend this methodology to understand a phenomenon that concerns us, which is environmental impunity. We understand that environmental justice is a current demand, and we have approached also with a open concept that tries to understand the changes of these phenomena such as climate change, but also the existence of crimes, environmental damage. And in April, we presented the first report that is focused on the 32 states of the country. And right now we are trying to do a comparative study in Latin America to see how prepared we are to guarantee environmental justice and to avoid that the lack of compliance of these objectives of environmental policies generate a damage in the environment that is even greater, or that promotes the destruction of the environment, but also increases the vulnerability of people, especially of those who are already vulnerable because of these inequalities. I would leave it there. Thank you very much. Thank you, Dr. Leclerc. And I would like to highlight two things that I heard in what you just mentioned. What you were talking about, the impunity levels and the findings. It was found today that the mean this year was in 94.8%. And you mentioned how the entities that present the lowest levels are in 76 or 86%, which is really high. And this is something that we may talk about by the end, about these institutional traps that are very complicated and how we have diagnosis and public policies and the different recommendations. And we see how different administrations come and go from different political parties, but they do not do anything, and this road continues to be the same. So this is something that I would like to go back to in the end. Now we are going to talk to Cristel from Mexico Evalúa for her to tell us about innovations on how it's being applied with Mexico Evalúa. Thank you very much, Maria Jose. It is a great pleasure for me to be here with all the people who are following us in the live stream. And it's a great pleasure for me to be here with you talking about impunity. Impunity is one topic that is of the general public's concern. And I think that we should start from identifying if all people think of the same when we talk about justice. When we hear impunity, we usually think of justice. In injustice, we think of frustration or social outrage, but we not necessarily have the same idea of justice for everyone. And I would like to start my participation with this. I would like to start talking about what we understand as justice and then move to sharing with you, as Dr. Juan Antonio Leclerc did, the different measures on impunity. I'm going to share a little bit what we are doing in Mexico Evalúa, how we are seeing it, and what we are doing to measure or to approach this impunity. And there were 2 points, very important points that were mentioned, to get to know the causes and the effects, because it's not the same just measuring and having a quantitative diagnosis of how impunity is than associating it to specific contexts or phenomena. If we can please share the presentation. Before starting, There it is, thank you. First of all, I would like to start talking about what is the context in which we establish the measurement that we developed from Mexico Evalúa, especially for people that are following us from other places. Maybe for the people who are in Mexico, it is easier to conclude what we are living in the country. But for those who don't know it, we live in a country with a really high level of victimization. One out of every 3 countries are victims of crime, and in 2020, this led to 20 million victims. One important element that I would like to highlight is with lethal violence. It's not the same to talk about different phenomena or crimes that we can have, such as injuries or damages, than talking about a violence that is affecting our most important good, which is the right to live. And I would like to highlight that Mexico presents a level of lethal violence compared to other countries with armed conflicts. 29 murders per every 100,000 inhabitants. And when we talk about different entities, we have entities such as Colima, Chihuahua, or Guanajuato, in which the rate of murders goes beyond 90 murders per every 100 inhabitants. And another element that I think is important to highlight is the fact that this violence is not affecting men and women in the same way. Or when we see violence with a gender perspective, we see it with a different way. In some cities, murders of men have increased 3 times, but of women have increased 6 times. we have had the largest number of cases of gender violence, and also with more than 700,000 calls for assistance to 911. And these were the ones related to domestic violence. This is just to have an idea of what we're talking about. And I think that it's very important to talk about the disappearance crisis that we are facing in the country. Right now, we are reaching almost 95,000 people that were disappeared. All these elements, I wanted to mention them because, as Juan Antonio mentioned, we are talking about a violence that comes from really large criminal structures that are becoming not only more sophisticated, but also they are having more impact in all social areas, in the financial area, political area, in all the areas we can see the penetration of the organized crime. And this sets a very important challenge for the agencies of the state that need to investigate and prosecute these criminal structures. Just to give you some information, according to the records that we have, the operation for drug trafficking created more than $3.2 billion, and this was equivalent of 71% of direct foreign investment this year, just to give you an idea of what we're talking about with this type of criminality. So what do we understand by justice? As I mentioned at the beginning, having shared a little bit of the context, I would like to say that in Mexico Evalúa, we conceptualize justice with an approach that does not necessarily mean a punishment. This means it has a wider vision. It may mean the clarification of facts. It may mean the pardon of the offender or the compensation for the damage, or as well a ruling, in which case, if the judging part determines, it will have a punishment. Now, the measurement that we do of impunity starts from two key premises. The first one is related to what Juan Antonio mentioned. If we have an open vision or a more narrow vision, we decided to measure direct impunity. And what does this mean? It means that we are not analyzing all those cases that were not of the case of authorities that we know as the black numbers. In Mexico, this is more than 93%. We are focusing on those cases that were known by the authorities, and we analyze in these cases what was the final resolution that they had in either measure that I mentioned. And the second premise is related to this vision that we are not only focusing on measuring based on the ruling, but we identified cases that were solved through alternative mechanisms or through different ways of solving them. And because either of them, we consider that there was a resolution of the case, a response for the victim and for the accused. Here, I'm only going to present quickly. This is the formula that we have been using in the impunity index. But what this formula means in simpler terms is that from the cases that were known by the authorities through the complaints, we identified which were not related to the competency of the authority. In these cases, the ones that were doing the assessment, and those that were related to the competency of the authorities. And then we analyzed if they had these three options: the alternative resolutions, the rulings, or anticipated exit. And we found this level that Maria Jose was mentioning, a 94.8% level. And this national average may establish what are the different situations that we have in the government, in the country's entities. And we have different entities that have higher levels than 90%. And this is very important because of two elements. The first one is related to the fact that not only do we have many cases in the black numbers, as we mentioned, 93%, but also the cases that were known by the authorities, they basically do not have a response. They are being enough to fill the institutions that are in charge of this prosecution. And the second element is that there are no prioritization elements. There are no plans of criminal prosecution. And we see that as a tool that the public prosecution may have to guarantee that the cases that are most important for the society, whether they are murder, femicide, disappearance, are not left in impunity. Not all cases deserve the same response by the authorities. There are cases in which the figures vary, but among entities, we can say that at least 40% of the cases may be solved by alternative measures. These are cases of robberies without violence, for instance, and we are saying that alternative justice is only used in 6%. So we are not using alternative justice, and we are not achieving to rescue from these impunity levels that you are seeing in this slide, those cases that should imply the prioritization from the authorities and establish all the investigation efforts. I would like to say also, and I mentioned it a few minutes ago, these elements or these cases should not be analyzed in an isolated way. This is one of the greatest problems. We still have public prosecutions and law enforcement that develop the investigation case by case, but we are not analyzing what is happening in this context. We are not generating intelligence that allows us to tackle or face these structures and criminal markets. And what is this leading to? Basically, to an impunity that can be seen from a structure, from the structure. 97% of crimes are seen in the local general attorney's offices. And as you can see in the different research that we have done of this index, we cannot see a significant change. At federal level, I think it's concerning to highlight that not only do we have a 95% of impunity, federally speaking, but it's the institution that needs to investigate the most complex crimes: drug trafficking, people trafficking, corruption, forced disappearance. All these elements are in this area, in the federal area, and it's creating impunity. So this leads us to rethink what we have to do to change impunity. I wanted to share this slide, and you may not see all the entities, but we can see what Juan Antonio was mentioning. We are not seeing a significant change in these entities, in these federal entities regarding the impunity levels, but this idea, these pictures allows us to identify some entities where we are seeing an escalation. We have the cases of Baja California and Guanajuato, and they are presenting highest levels of impunity. We need to analyze what is happening there. And we also have the cases such as Zacatecas that actually has a sustained decrease of impunity. Probably it's associated to the use of alternative justice. That's what I wanted to mention in my first participation. Thank you very much. Thank you, Chris. I'm sorry that I just opened my microphone, but I'm taking notes of everything you say because I think, as you mentioned, the diagnosis to understand the other situations that are happening in the national context and being able to create courses of action, I think it's very important, as you mentioned, to see the size of the actions, to know the complexity of the organized crime that we have in the country. Now I would like to give the floor to Elvin Diaz from the Institute of Guatemala, for him to tell us a little bit about his experience and how they approach impunity from there, and what are the best practices that you have seen as well. Good afternoon. Thank you very much, Maria Jose. First of all, I want to thank the organizers of this event, and I would like to greet my colleagues with whom I'm sharing this panel. I have been very interested in what you just mentioned, and it's unavoidable to bring all these formulas, these experiences, and the paradigms that you're working on since the judicial reform started in Mexico. And I need to think about the situation in Guatemala. We need to take into account that Guatemala was the first country that started with this transition to this context, and in a very complex model. This model was, this adversarial system was trying to establish the very specific situations that we could see. So we see the justice system according to this. We stopped a armed conflict after more than 30 years, and we had a political proposal, and through the transformation of the justice system, we may have perfected the way of managing the conflicts, especially in a model where we could respect the fundamental rights of people. These are like the greatest promises and ideas where all our theory has become established in our books and manuals. And also the criminal adversarial system was established like this. And in the last 30 years, it has been very complex because of issues that are very related, many in a minor scale, but they are similar to what Mexico presents. Really high indexes of violence, really high levels of murders, violence against women. Actually, violence against women in the last 5 years, since we have had the specialized law, is one of the highest, the greatest crimes that we have. 17% of our crimes is related to gender violence. And we're trying to see the criminal policies to see what type of responses we may give. And we don't know if this is the only response that we may give. And obviously, during all this transition, we have been affected by several expressions of organized crime. And during the last 30 years, or in the last few decades, we have had different reactive administrations from the people who are in the top positions of the justice institutions. We need to be able to perfect the capabilities that the criminal system has for the management of conflicts. In this regard, institutions such as the one I represent have tried to stimulate the judicial and social investigation for the criminal system. We need to try and contrast and compare this to the ideas that we have. And with all the diagnoses that you have had in Mexico, we have a lot of similar results, especially with what Juan Antonio and Cristel mentioned. What are we going to understand as impunity, and when we talk about direct impunity? However, when we see realities, not only of the capabilities of response from the public prosecution, but we also see other works that the justice system may give, impunity is a wider or a larger concept. Actually, it's the concept that Juan Antonio mentioned, this open impunity. And this is where we can see the severe violations of human rights, the victimization that Cristel mentioned. And we're thinking about a wider definition, and that's why we're working on an initiative that we call Mirador Judicial. You have access to that through the website of the Institute. Here we have seen 4 aspects of this assessment. It's actually 5, but right now we are only working on 4, and these are related to a methodological basis of access to information with indicators. We are having 30 indicators, and in a couple of them, I want to mention to what we understand as impunity. We have talked about impunity in a direct way, I think this is a concept that was established here in the panel as well. Right now, after 10 years of the exercise of assessing the justice system, we have entered a very strong dilemma because of the type of definition that we may consider as effective or not. I want to share with you what this is because Cristel also mentioned it, and this is something I want to share with you so that you can see what we consider as impunity. For us, from our criminal system and with a more political point of view, we take into account income directly or the entries of cases versus the records that we have in other institutions. These are responsibility of the people that are responsible of these criminal actions. And also the foundation that Cristel mentioned, this formula is used in several countries. The CEJA has been encouraging this methodology of studies, and in Mexico you have used this as well, and you have elaborated in this wide concept of impunity. We have this formula, and what we have found in the last field work, we found that 10 years ago, we installed new figures and new ideas in the criminal system to establish the indexes in order to give effective responses to victims. What we found, unfortunately, and this is a situation where we see the criminal prosecution, we have found in the last few years, in the case of Guatemala, we are presenting an alarming amount of cases, and we must make transparent the use of policy when there is a disregard or the dismissal of cases, because dismissal is an important concept in order to measure impunity. We have left it for this study. We have left it behind because we have seen in the last 4 years in the current administration a great use of dismissal. So we need to check, we need to see that this is part of the institutions, and this is something that gives light to a not transparent use of these effects in the institution. And I am talking about the Central American region where we have seen this a lot. And I think that with the excuse of closing cases, we are trying to justify a political measure that is not transparent. So I think that what we found is to reverse our formula that is not going to be so different to what was exposed in this panel. And we are trying to have the cases enter, the pending cases, and those are the cases that for us represent direct impunity. And basically, the rate of impunity in the last 4 years has gone beyond 90% in the criminal system. And this is an alarming information because in the previous administrations, we were able to reduce this rate of impunity. And right now we are going to find a contrast with the current administration that has implied several setbacks. I would not like to elaborate a lot on this, but here I would like to highlight something that is really concerning because of several criminal phenomena. And based on these phenomena, the effectiveness rate is actually very reduced. For instance, a general attorney's office that had presented important data was the Office for Homicide. Because of the high rates of homicides that we had had in the last few decades, we established what we call the proactive or intelligent criminal prosecution in a way to analyze this criminal phenomena and breaking the scheme that we used to have as a traditional response scheme. We established special elements, specialized teams, criminal analysis as a basic tool to do is we were able to make this office an institution we were able to create institutions against organized crime and to see murder as one of the variables of their crimes. And what we are seeing right now is that the impunity rates are still back on the rate that we had before, which is between 7 and 9%, when in previous years we were able to reduce that gap from up to 25%. And I think that we need to take into account these learned lessons, because not making them institutional with these policies that are more permanent and that can vary, we cannot see the achievements that we've had. That's why the information that I mentioned that maintained a very similar policy and who were trying to transcend this investigation, this more proactive investigation with more white-collar crimes, where we can see different figures such as money laundering and corruption. This is also a contribution of a part that is very relevant in Guatemala. Let's remember that my country was also the first to have as a commitment from the peace agreements to have this external representation of the UN, which was the International Commission Against Impunity in Guatemala. Their mandates were very well established, and they were related to reducing the levels of impunity, but it was focused on the criminal structures that were in these areas. So the lessons that we can learn from this process is that the fact that we didn't ensure these processes of transformation is creating negative consequences in reality. And I'm only talking about the inability to respond. And I'm talking about the other administrations that were able to increase the level of effectiveness. We are now having an administration that has these setbacks. I will leave it there. It's just to share the experience of Guatemala and to compare it and to see the things where we agree with you in Mexico. Thank you.
Thank you very much, Elvin. In theory, our panel should finish now, but I want to take some 7 minutes at least for some Q&A in case there are some questions from the public. In the meantime, I want to make you some questions about what you have just said. And I want to get to the innovation part, which is the theme of this forum. The first question is, what Chris was saying with regards to alternative justice, how can we go back to those cases that need to be a priority for the judicial system? I don't want to say to decrease, because we still have 76 or to 80% of impunity, but how can some officers, some public prosecutors or and attorney general's offices have used alternative justice? Who would like to speak? Chris. Thank you. I just want to say, with regards to innovation and what you are saying, I think that there are two important topics to highlight, especially when we think about innovation, which is not only technological. This can be a different way to do things. The first of which concerns the fact that usually we associate impunity with a lack of institutional capacity in terms of staff. But the immediate answer is to think that we need to increase the staff. However, there are cases, and we can exemplify this in Mexico, where the capacity is enough for the cases being solved and addressed. And it's true that the impunity levels are very high. One of the ways that from Mexico Evalúa and from several other organizations and the academia have analyzed considers go to strategic criminal justice. And this is not about establishing what the phenomena that are going to be prioritized and what the type of answer we are going to give will be to those different phenomena. Then we can distinguish the cases that can be solved by alternative justice, and then we can have facilitators that could help reach an agreement and a remedy, while in other cases, we should bet on an investigation and other type of elements. I think this is an effort which is not clear in Mexico and that we need to try. That transit should be done not just from a desk, but from institutions hand in hand with the society, the academia, because in the end, it's all of us who are affected, and we can help to define the priorities. Thank you, Chris. Dr. Leclerc, or Evan, would you like to add something about this? I agree. In terms of the results consequences, I am concerned that 24 states were having insufficient performances. In our case, it's 25. You have the same fill over and over. Now, with relation to phenomena, impunity phenomena, I am concerned that we need a simultaneous agenda so we can face impunity. We need to advance a lot in the justice system. That's a goal in itself. But to overcome impunity, we need to advance in security. And if we advance in one and not the other, we're going to have the same, and we have the same levels in the other one, we are still going to have victims of violence and a lack of sufficient competences. The same happens with corruption, with violence, with the penetration of organized crime. We should think about the simultaneous agenda, how to maximize scarce resources to give a comprehensive response. But we know politicians understand comprehensiveness as something void. That's one of the main failures of the criminal system. We can modify access to justice, but if there is no link between streamlining of the police and the Attorney General's offices, this won't work because you have all of the elements disconnected and with a different logic. If you take this to the federal state level or to the federal level, I agree with Christelle. In terms of impunity, a fight against impunity, this is a huge challenge requiring of innovation measurement, which are more complex. Yes, would you like to add something? This is an idea by Alberto Inder, how this is being conceived from a criminal police. And the doctor has said this to give an answer to the levels of impunity. This is not just for the criminal system. This requires a failing institutionality. And when we get to the criminal system, this is just to reduce something that failed before. The high levels of criminal justice and figures and exponential judgments, those are reflections brought about by this. We think about dispute management so we can boost these in different disputes. This will allow to decrease the burden of the system when we approach it. This is a challenge, as the doctor mentioned. We must consider prevention, otherwise our response would be very limited for impunity. Let's remember, impunity is structural to the criminal system, and this has been shown by texts. We will still have impunity, but in our countries we see a high level thereof and of workload. It's not just about the lack of a response, but the insatisfaction of the person that approached the court. Thank you very much. I know we don't have time, so I want to close with this last question. We even have a documentary, a Netflix documentary, and this topic is the seriousness of the situation of a problem which is not unique to Mexico. I am concerned about, well, it's important to have this human capital willing to advocate for these cases. And of course, this will entail doing this investigation at one's own risk. How in Mexico, I don't know, Guatemala, what are the best practices for people who want to devote their life to that part of the investigation? What centers should be improving their education in terms of what the academia, the civil society have to do? So the police are really actual investigation police officers, and so they feel safe. And this will be our closing question. Who would like to start? Chris, you are covering a key topic which concerns the staff's conditions, the ones who will be developing, making the decisions, developing investigations, or assisting directly the accused or the victims. More than speaking about the institutions, then have to be preparing them to get to the security agencies or justice administration. I think we have to rethink the way in which we are building institutions. There is no professionalization service for the staff that goes beyond the initial selection, that really offers dignified working conditions, security, certainty, and allows them to conduct their work with operational independence. These topics have been left aside, and we should go back to them. Otherwise, we are preparing people, specializing people, and there is such a level of rotation that we can't retain talent at the institutions. Thank you. In our case, our last year's bet has been to strengthen their professional career at the investigation responsible institution, not just the investigation career, which goes to the police, but also the Attorney General's office career. They're responsible for the investigation, assume a series of risks and challenges that is who are people exposed when we think about prosecutors that investigate groups with considerable structures. This has to be given in a modern criminal justice system with specialization areas. At least I can tell that in my country, this has not been addressed properly. We have no clear policy, even if there have been efforts for the implementation. So I think that those guarantees should be allowed, not just to improve the quality of service that a servant can do, but something which is but for the guarantee of its impartiality and all the elements they need. I would like to make a comment about history. Crystal said something. When we discuss capacities we are required for more staff, and this is a completely wrong stuff. Part of impunity, of the impunity problem in terms of capacities, is that more than discussing the staff problem, we should discuss the capacity of agency given by the people providing a service at our institution, so we can guarantee rights. This agency can destroy the capacity of the state to give a response, and sometimes this concerns the specific environments where people working on behalf of the institutions have to conduct their activities without having an agency capacity. And also in settings where corruption is the constant element, becoming a civil servant is difficult because they are seized by corrupt networks that demand that you act in the same way. If being a police officer makes you a target of the organized crime, and your family has no guarantees in terms in case something happens to you, they have no social security, so you have no agency. And curiously, this is something that the organized crime has understood very well in this country, because one of the strategies is to destroy social, citizen, religious, environmental leaders, agency, destroy the capacity for any type of response. And I think that this is something that we should start discussing when we speak about capacities face to impunity. It's not just about adding more resources, but linking them to strategies, to policy lines, and for that stuff to really have a capacity of action from a very specific concept of agency, given other problems that we are faced with. Thank you very much, Doctor. And I want to close with that topic, with that link. I think that's a very good word for this table, with the studies you conduct, with the methodologies, the shared methodology that we have. Thank you very much, Cristel Rosales, Elvin Diaz, and Dr. Juan Antonio Leclerc for having been with us at this table. I learned a lot from you, and I hope that those who are watching this video will learn a lot as well, and I invite you to continue with us for the last part and the last day of this forum, but it will be available for you to see. Thank you, everyone, and greetings.
Muchas gracias al panel. Muy interesante las reflexiones que nos dejan y sobre todo muy importante el tema de impunidad, tanto en México como en la región, y las diferentes formas que esto se puede abordar. Podríamos llevar a la acción de la política pública. Por el momento vamos a tomar un receso y regresamos a las 15 horas, horario de la Ciudad de México, para continuar en este segundo Foro Internacional de la Innovación en la Justicia, con el tema de justicia abierta y posteriormente competencias de personas operadoras para una justicia de calidad.
Muchas gracias.
Cuídense mucho.
Hasta luego. Gracias. Cuídense mucho.
Muy buenas tardes, bienvenidos sean de regreso a este segundo día, a este tercer día del segundo Foro Internacional de Innovación en la Justicia. Ahora continuaremos en nuestro panel de Justicia Abierta. Modera Jorge Carvajal, investigador del Programa de Justicia de México Evalúa, y participan la ministra Ana Margarita Ríos Farjat, de la primera sala de la Suprema Corte de Justicia de la Nación, Álvaro Herrero, de la Red Internacional de Justicia Abierta, María Barón, de la Fundación Directorio Legislativo y del Comité Directivo de la Alianza para el Gobierno Abierto, María del Carmen Nava Molina, del INFO-CDMX. Le dejo la palabra a Jorge Carvajal. Muchas gracias.
Thank you very much. Good afternoon. I am Jorge Carvajal. I am a collaborator at the Justice Program at Mexico Evalúa. And it's a pleasure for me to be in this panel, in this forum, to speak about a topic that I am passionate about. And this is a topic that, without a doubt, open new perspectives and horizons with regards to justice. And here we're speaking about open justice. I greet the panelists, Justice Ana Margarita Ríos, Maria Barón, Maria del Carmen Nava, and Álvaro Herrero. In this panel, we will address the topic of open justice, and we know that it has got different perspectives. I would like to start with a reflection with some data that I think are at the core of what we can expect to be addressed by open justice and an open state. These are deep matters that are very rooted in the justice matters of our country. According to the Latino Barometer, Latin America shows a high level of skepticism with regards to the judiciary. From 1995, the trust percentage in this institution does not reach 40 percentage points, and it goes between 17 and 23%. For the last measurement, it reached 25%. This report says that there is weakness in the region's justice, and this significantly affects democracies. Furthermore, there is a perspective that the judiciary is considered one of the least scrutinized public powers. The judiciary is considered as a conservative, formalized, hierarchical branch of power, and therefore, in here we're speaking about trust, effectiveness, and efficacy of these institutions. When we speak about an open state, we can speak about a new paradigm in the exercise of civil service based on the principles of transparency, citizen engagement, accountability, and innovation, with which we aim at building governance, transparent governance models, and also justice which is accountable and responsive. Open justice comes after an open state focused on the judiciary, and the open parliament, which focuses on the legislative power. To recover some data on the progress in terms of the disaggregation of the approach, the policies, and open state practices worldwide, we can start from this milestone of 2011, which was the Statement of Open Government, upon which the Open Government Alliance was founded, and of which Mexico was a founding part. Today we have 58 countries and 76 jurisdictions or local government. We can also see that stemming from an instrument and a central tool being used for the processes promoted by this alliance, which are the action plans for open government. From 2011 to 2018, 132 engagements between the authorities and the civil society and the society stakeholders took place. Out of these 132, well, they represent 80% of the total, and they are related to the topic of justice and open justice. This is a relatively low number, but we do have antecedents of this practice. The justice field establishes conditions and specific challenges for the incorporation of the rule of law approach. When we speak about open justice, what do we mean? Well, with regards to solutions of disputes and addressed by the judicial system and the guarantee of rights and the administration of justice, or in the institutional openness. Also, we have to consider, and this is an approach we use at Mexico Evalúa, that justice systems, especially in criminal matters, cover not just the judiciary, but also the public prosecutor offices, the public defender offices, and the prison system. In this panel, we will be addressing specific topics related to the challenges and the relevance of open justice for the creation of a more effective and transparent justice system, the transparency principle, and what new tools can facilitate access to judicial information. We will be speaking about the judicial information and its relevance in the promotion of the participation and the citizen knowledge. Public knowledge, which and socially useful public knowledge, and also the legal language. We have seen this topic a lot in other panels. For instance, that of vulnerable people. We spoke about the barriers with which they are faced and the good practices of open justice in the region. This panel will be developed through two presentation rounds of 5-minute turns each, and we're going to be using as a benchmark some questions. I will give the floor first of all to Justice Ana Margarita Rios. She's an attorney of the School of Social Sciences and Law of the University of Navarra. She has a master's degree in fiscal, and she is a master's at public policy by the Technological Institute of Monterrey. She has over 2 decades of experience and professional exercise acknowledged in several institutions throughout her career. In December 2021, she was appointed Justice of Mexico Supreme Court of Justice. And I would like to have as benchmark justice, the way in which the principles have been taken and adapted to the judicial part. I mean, open justice principles and how open justice relates to human rights. The floor is yours for 5 minutes. Thank you very much, Jorge. I'm going to take a little bit more, some of these 5 minutes to greet those who are with us today: Maria Baran, Alvaro Herrero, Maria del Carmen, and all the people who are following us and that have been following this forum. Before coming in, I did not have the opportunity to tell you that I am very honored to take part in this forum, and it's an honor to be with all of you. You were mentioning in your introduction, Jorge, this new management of open government is a new governance way, and maybe the last resources of the state in which the philosophy and the open government philosophy has completely transitioned to, and this is the judiciary. Maybe I don't think it's because of a reluctance or any inertia. Undue inertia, if we had basis to consider this as undue, let's say an institutional reluctance, as this could be the case in other institutions. So rather than a reluctance because of this, we do have some kind of a jealousy with respect to the work, the information with which we work. We have methodologies here, and the matter of associating the justice apparatus loneliness to the fact that there may be a lack of agency. That does not mean that we have divorced the principles of injustice. I think we are headed this way, but I think there are very important challenges, and we can differentiate them maybe in terms of judicatures, the federal one on the one hand and the local justice on the other. And I think that I can have here some generalizing basis that justice entails, but I think that local justice is lagging behind with respect to direction towards the open justice principles. Now, if open justice is about linking the citizen participation, so participation, collaborative work, policies are created, and not just transparency and accountability, but to achieve social, sensitive, effective justice that society feel its own, and that can be, and for them to deploy their rights to justice, it's necessary for this communication with society to exist. The judicature cannot act as if they were divorced from the society within which it must administer justice in terms of what society has agreed for it to be. Society has to gauge it, and society changes in a way that we always have this understanding, and not just transparency per se. So in order to achieve this right to justice, we need transparency and accountability, collaboration, and civil participation. We have a lot of challenges here. And I was mentioning this in another intervention. According to me, we have to see the local and federal justices journeys. It's easier to follow the local justice, and it has very visible aspects for which through which we can measure them, because the hearings of Mexico Superior Court of Justice are public, and I think that's an important differentiator. And we have differences here. The risk of being speaking with regards to people when people who are going to be, and not just as is going to be debate, closed door debates. We have access to information, and how we are going to be considering this. I'm not sure if I have another intervention, because I'm not sure if I think I see that I have a clock there. I think I've used all of my time. Yes, you will have another intervention there, so we can stop here and then we can move to the next intervention. And now, very well then, thank you, Margarita. These are very clear topics indeed with regards to the need and the convenience of adopting this focus in the judicial practice, and also in terms of the challenges that we are going to be addressing now. Now I will give the floor to Maria Baron, who is the executive director of the Legislative Director Foundation. She's specialist of international relations by the University of Bologna. She's a candidate, a PhD candidate in political science at the San Martin National University, and she has worked at civil society organizations in Argentina and abroad in order to decrease the anti-ethical practices by civil servants. And she has published 7 editions of their works, who legislators are and how do they represent us, and domestically and in other districts of Argentina. I give the floor now to Maria Baron. Welcome. Thank you very much, Jorge. First, I would like to greet, of course, my colleagues at this panel. First of all, Justice Rios, and of course, Alvaro Herrera and Mary Carmen Nava, great colleagues with whom I work a lot, and in open justice governance. I can start, or do you want to make me a specific question? Well, let's go back to the first question of the challenges. Right? Yes, how the open justice principles have been adapted to the judicial field and how they relate to human rights. I would like to take one step backwards before with regards to the context of open government, the alliance for the open government that is going to turn 10 years this year, since it started in 2011 with those presidents who were fostering this agreement between different countries. And you were saying this before, we have 78 and 10 years ago only, we started to speak about open government and transparency and accountability. Today, in many of the countries, including Latin America, we're not speaking about open government, we're speaking about civil space, and we're speaking about free and fair elections. So I think that for me, that's what it is, what the world has become, not just in terms of the pandemic, but that's the context where we are now. Open justice, we can work on that as well, but that's the other scenario, the more difficult scenario. So that's the context, and also CSOs are the counterpart in a more critical footing. And to go to your question, and as not to repeat what Justice Rios was saying, which is the work that we have been conducting from the Legislative Directorate in the region, in which we consider everything that concerns the legislative initiatives and the implementation of regulations. Also, we have the principle of this from the beginning of the Alliance for Open Government, and we can say that the members of the Alliance in the region executed 105 regulations which concern anti-corruption, transparency. These are laws for the improvement in the access to information, against lobbying, final users, and so on in the region. At least in these last years, we executed 150 norms.
Now, if we ask the civil society organizations that work in this area, the organizations feel this debate that is being done is that we need more. And more than 150 regulations, and there is also a gap, which is something that we have since before the pandemic, not only with regulations against corruption that are also related to the short capabilities that the region has to implement new regulations. I think that's one of the greatest challenges, and it includes the legislative and judicial branches. And also, I think that the greatest challenge is if this space is useful for us or not. And I think that for the governments and civil society, yes, this space is useful, but we need more. It's better to have than to not have. And regarding human rights, and I will finish with this because I know I only have 5 minutes, we can trace a line before and after the pandemic, and actually in our experience, which is the 5 rights that are related to the civil space in almost all countries, which are reduced areas because of the pandemic, today that we are not in the beginning, we have not gone back to the place where we were before the pandemic in terms of rights. So to conclude with an idea, in this moment of increase of the systems and debts related to institutionality in the region, we have some old debts that are presented as great challenges. The human rights issue, or the civil space issues. There are a lot of organizations working here, and we are expecting not only civil society organizations, but also we expect to have more responses, and we need to see how to do that. Thank you very much. Thank you, Maria. Yes, indeed. When we talk about direct justice and opening procedures, we need to talk about the will and the commitment that is done from the different institutions, and also the civil space and the civil society stakeholders, the non-government stakeholders that make this effective. So I think that the things that you're mentioning are important because that's how we build conditions. Well, to continue, I will give the floor to Álvaro Herrero. He's an expert in governance, transparency, the rule of law with experience in Latin America. He has worked nationally and internationally with NGOs and different international organizations such as the Inter-American Development Bank. And he has been consultant in different programs such as the UNDP, the USAID, also the IDB and the World Bank in more than 15 countries in Latin America. He was executive director for the Association for Civil Rights, and he was also in the board of the Laboratory of Public Policies and Citizenship. He was also the Undersecretary of Strategic Application and Institutional Quality in Buenos Aires since 2015 until 2019. It is a pleasure to have you in this panel. The floor is yours for 5 minutes. Good afternoon, Jorge. Thank you very much for the invitation, and as well as my colleagues, it is a pleasure for me to be here in this panel and in this important and necessary event to elaborate on the discussions about innovation and justice. I totally agree with the comments of my colleagues, and I wanted to share a slide that is related to your question on how the principles of open government adapt to justice. And I think that the good news is that there are a lot of facts and there is a lot of experience that we have in the region, both in Latin America and the Caribbean. And I think that with this experience, we have the challenge of collecting it and applying it to the justice systems in the region, to the civil society organizations and the academy. I think that there is a first generation of reforms of open justice, and we didn't call them like that 10 years ago when, as Maria mentioned, we created the Alliance for Open Government. We were talking about reforms of institutional quality, institutional strengthening, or reforms that went with the judiciaries, and then the transitions to the democracy that different countries underwent in the 80s. And there we have the three pillars of the open government: transparency, citizen participation, and collaboration. And we could see them in different ways, different agendas that may be well known for some of us. In transparency, we talk about the access to public information, the publication of different types of declarations, the elemental ideas of the different parts of this. And in citizen participation, there were some parts of the judiciary that were related to going to the territory, listening to the citizenship. In Costa Rica, there is a good show called Justice Go to School, in which the people from the Supreme Court in Costa Rica went to the different territories and they had conversations with the schools, with the students, and also with other organizations. In some cases, they did some surveys for citizen satisfaction for them to know how was the perception of the people of the justice system, because there was a really low level of reliability. And also the public hearings and different tools that have been advancing in these areas in the region. And in collaboration, maybe we have very few experiences. The Supreme Court started working in the different portals where they put the information for the audience, but there was no space of collaboration per se. And this agenda became stronger, it started to improve. And right now we see a new generation of open justice reforms. These are clearer, more compact, and more established. And in transparency, we talk about active transparency, we talk about open data, we talk about the implementation of different standards, open contracting. In the judiciaries, there are different judiciaries that are working on this. We talk about the use of data, evidence-based policies, accountability based on data as well. And in terms of citizen participation, the agenda has exploded in a certain way. We have clear language, the use of social media, which has been very important to reach the citizens with the judiciaries, and the processes of strategic planning, where the processes are open for the intervention of the citizenship. And we have different classic areas. And in collaboration, I think that we have new tools, new stakeholders. We have the innovation laboratories, our models of public innovation that come from the executive branch and that are now being used in the judiciary, the use of social media in a more collaborative way where they involve citizens more. And the citizenship is using right now social media for everything. And then we have some networks in the region, the networks for the organization of the civil society. In my case, I represent the Network for Open Justice, but the idea is to generate knowledge, to share it, and strengthen the capabilities of the judiciaries in the region. I don't seem to sound like I am overly optimistic. I know that we are living very difficult things in terms of this open government and the civil space, but I want to share that there is a group of reforms and knowledge and we need to make an effort to document it and to put it at the disposal of the justice systems in the region, because many times we hear with a great concern about the lack of knowledge that there are different reforms that have not been implemented, but in the region there is a space of reforms that have been applied, and it's necessary to collect them so that they can be used by the community of justice in the region and in the world. Amazing, Alvaro. I think that this allows us to compare the challenges for the implementation of these principles with practices that may not exist currently. And for this, Carmen Nava, Maria del Carmen Nava, is a specialist in the theoretical and statistical application for the creation of theoretical models in political sciences. She studied in Washington University in San Luis. She was the coordinator of Transparency for Open Parliament in the Assembly of Mexico City, and she is right now the Citizen Commissioner for the Institute of Transparency and Access to Public Information, Data Protection, and Accountability in Mexico City. Maria del Carmen, it's a great pleasure to have you here in this panel and being able to hear you, how your ideas are about these topics. Thank you. Thank you very much to Mexico Evalúa and Frederick Newman Foundation for the invitation to this forum. I think that it's very important and timely to spread the information about the different areas in the state, and the judiciary has its own logic, such as the legislative and executive branches, as well as the autonomous institutions in the state. Thank you very much for the invitation to be with you, Maria, Alvaro, and of course, Justice Margarita, and with your facilitation, Jorge. Thank you very much. I would like to take a step back. How did we start talking about open justice, for instance, through public hearings? In the case of Mexico, as we all may know, just in 2020, we had a reform so that we could have this obligation of making all public hearings transparent, because before they were only based on the decision of the people or those that were of public interest. And since 2015, they had this idea of the obligation of transparency in the Mexican case. With this reform that was applied nationally, basically all the states need to make their hearings public. And in this framework, we are working in Mexico. And I would like to talk about a wide spectrum of justice, of open justice, which goes beyond the judiciaries, as you were saying at the beginning as well, Jorge, about what other institutions of the state are involved, not only in the administration or in the creation of justice, but in the decision-making that imply a warranty, an application, and a human right, or have a certain relevance when looking for solutions for the conflicts. And in this regard, this wide spectrum includes the general attorneys, the human rights commissions, and the autonomous organizations that need to guarantee transparency, as well as the election courts. All of those that are looking for public authorities to contribute with the responses and resolution of conflicts among people, authorities, and groups, as well as communities. In this case, I think that we need to go towards having an open justice in this wide spectrum. I think it's very relevant to have this uniformity of what these institutional politics or policies are in that, as we mentioned in the beginning. And I wouldn't say only in Mexico, but in the world. After 10 years of OGP, as Maria mentioned, is to take these important elements of institutional openness to the daily exercise of the institutions, as well as for the public decision making. And what are the criteria to make decisions, to analyze public policies, if this is related to the interaction and mapping of social needs that through the collective intelligence may be leveraged to make decisions and to take timely and to give timely responses. I think that in this regard, we have developed an open justice panel where Mexico Evalúa worked along with Tojil and also Justice González Alcántara. Also Mexicans Against Corruption and different groups where there was a collective interest to boost these steps of having more open justice. And in this first intervention that I have, I don't know if I have enough time, but I would like to mention, especially about a case that we had and we made public, because sometimes we talk about institutional opening, but the response is how? How do we do it in a simple language that makes it accessible and with a feasibility logic according to the resources, both administrative and in budget or in human resources that we have. And in the Commission of the National System of Transparency, we did a guide according to the International Network of Open Justice. And thank you very much for your contributions to this cooperation guideline that uses this simple language and makes it accessible for the rulings. And this is a tool that we are making available on how we establish this opening as in a document that is important for the administration of justice through public hearings, and both in the jurisdiction, as I was mentioning, in this wide range of justice, in such a way that I think we are moving forward in this expansive way of having institutional opening. And the idea is of contributing with these good practices and documents that may be useful for different communities. Thank you very much. Thank you, Maria del Carmen. I want to also use this panel and this space to share an experience that we are encouraging from Mexico Evalúa, which are exercises of dialogue and feedback on the development of the criminal justice system locally. And we are taking the approach and the principles to take advantage of this. Even though we are focusing on criminal areas here, we perform an exercise in which part of the results to the assessments that we do every year and for which we give our reports. Since last year, we are creating local findings, and we have analyzed in a more detailed way the criminal justice system works in different areas in the country. And starting with that, we start creating an agenda and then a series of topics that are addressed directly with the authorities of the justice system. From that, we generate commitments and we do a follow-up of those commitments. And once they are set, the idea is for them to have improvements, and these improvements should be seen in the next assessments. This was an exercise that we did since last year, and we are replicating them this year. For us, it's very important to follow up these processes, and it's also a way of understanding open justice and also for taking it into practice. And something that Maria del Carmen and Alvaro mentioned is that these are methods that allow us to understand and apply these principles, especially with this approach of generating knowledge, of generating learnings that at the same time are part of this type of approaches. We are going to have a second round in the same order as we did the first time. And here I would like us to focus on the practical part. Some of you have mentioned some elements, but I would like you to help us understand in a more specific way the how to put in practice this open justice model, and how would that be different from a traditional model in the justice system. Where do we have this breakthrough in different practices or in different aspects of the exercise, especially in the judiciary area? And on the other hand, what is the role of the citizens in a process of open justice? We know that there is a diversity of expressions in terms of the citizenship. We have the users of the justice systems, we have the associated, because the associated parts because of all the things that we have, and it is worth reflecting on the role of these processes of openness within this judicial area. And Justice Maria, you have the floor. Well, in terms In judicial terms, open justice has three axes: a judicial governance that would identify the judicial procedure itself and rulings themselves. The rulings is something very delicate, and I am going to focus a little bit more here because judges not only decide on the specific cases, we create opinions. Judges create a speech and they establish values, what is allowed, what is not, what is abusive. And it is important for lawyers and for social anthropologists and political scientists. This is also relevant, and it's fundamental to know them, not only to give society reliability on the fact that what is being decided in a good way. It's the right to justice that I was mentioning, which is according to law. But they also need to know what type of law it is, socially speaking, what is accepted, what is allowed, why is it useful for us to know this? I think that this goes beyond this partial justice, beyond going to public speech, but also to implement public policies. What needs to be corrected? What are we missing? So I think that this is something where we can talk about the hierarchy, the organ, its known dimensions, but we need a lot of things about the judicial order. We have local hearings in the family area, and we may know a lot how the family law is applied in different areas, how many cases are because of divorce, or how responsible we are from our children. And when we're talking about alimony or divorce, if this information is being managed with statistical demographics, we have judicial issues, but we also have public policies. So what are we missing here? I mentioned that we have two ways, local and federal justice, and there is also a document that I thought was very important when I saw it. It's called Injustice Open for Women, where they are comparing the different entities in Mexico on how much access do they have to rulings. Some states of the country know that some of them are of public interest, but they do not publish them. And Maria del Carmen was saying that according to the reform on August 13, Article 73 of the General Law of Transparency, what is this going to mean in the publication of rulings? This is going to take necessarily to a new knowledge or a systematized knowledge of the sentence of the rulings. Who is going to do this? Who is going to handle this? So in this regard, the same way there is this in the judicature, in the judiciary, we need to talk to the society, and this understanding is reciprocal. The judiciary resolves, the judges, everyone is participating in the resolution of a matter. We are using our time and our capabilities, but also who is going to order it, to organize it? How is it going to be disseminated? Not only the resources of the human resources or material resources. So I think it's amazing that this general law of transparency was reformed, but also I think it's necessary to know how to apply it into reality. And also, it's not only about the judiciary or the judges, but also the academy, because the lawyers that work in the judiciary and giving them their intelligence and their knowledge, they are not used of using a plain language for the citizens. And with these practices of governance, there is an issue that we need to apply, and that's where we need this participation of the general society. And that's what we need in this language during these decisions. And that's why we do not necessarily have this easiness, and we need this type of decisions, and this generates a lot of work. So we need a participation that is really robust and round with the academies and with the judicial institutions, so that this education is not a double work for all of this. So I am optimistic, and I would close about this. And I think that this reform is very good in the judiciary. We're moving forward. And then yesterday we received 2 prizes in the contest by the INAI and the authorities on innovation regarding access to justice and transparency. About the search for solutions for human rights that are easy for people. And starting with COVID, we had all of this that was very well accepted to process the electronic signature and to be able to have a judicial process electronically. And I think that this main point is the organization of the information. And I think that I will leave it like that. Thank you very much. Yes, it's a very interesting way of presenting this, on how to do all of this a reality and take advantage of this openness. And continuing with this topic, Maria, can you please share your remarks on this? Thank you very much, Jorge. I think obviously you asked the million-dollar question, how to do it. I think that I would split this question in 3 types for an answer that I think one relates to the other. And obviously it's partially and totally open to debate. But I think that the first thing I would like to say, in the legislation directory, around every 6 months for the last 3 or 4 years, we have made small questions, I cannot call it a survey, to different organizations of the civil society that work in the different countries that create the GPs in Latin America. These are questions to our colleagues, essentially. And every 6 months, we ask them very specific questions that are related to their work in this community. And there is always one question that is related to what is the darkest power of the state? Or we vary this question. What is the one that has the lowest influence, or where there is a least rate of response? And as we were saying at the beginning with the data in the Latino Barometro, in all the questions, the judiciary is the one that receives the worst rating by our colleagues in the civil society. So I think there are more problems for working with the judiciaries in any of their institutions than other branches.
I think that in here we have got some important data mentioned by everyone, and it's the little access because of 1,000 reasons, but there is a specific access, poor access for the civil society to be able to participate. Number 2, stemming from this, I think that because of that reason, there is a very interesting project that about which Quechua Alvaro will tell us, which is called Whose Lab, which was generated in the Council of the Magistrature of the city of Buenos Aires. It's at a subnational level. And in here we were speaking about this, the access for the citizens in general to the judiciary, and what the legislative branch is, what its institutions, stakeholders, actors, the data are. And what's the regular, classic, traditional model of a cause at the judiciary? All of this for the citizens in general is this is a dark, this is a question. And I think that this is a very interesting project that tried this from its basis, like the justice was already saying, the language of the judiciary, for a caste that belongs there too. And if you can Google it, I would do it. And what this project has is that it has a call CSO, so the journalists, the academia, you were speaking about them before already. And the next point stemming from this, and this is the work that we conduct from the steering committee of the Alliance for Open Government. And this one concerns the level of creativity that we must have as organizations, as activists, as civil society activists to address this type of topics. It's no longer, as it was before, promoting a law or speaking to a legislator. We have had to become more complex in our initiatives so that we want to specifically with what concerns the judiciary, but also with regards to other institutions. And just to mention some experiences, which is one that we have developed, and this is how I'm going to be finishing. There is experiences that we had throughout this year within the JT committee, which is a call to action, and we tried things that we hadn't done before, and we tried initiatives that no one before had advanced, just to see whether the result would change. As we say, we always do the same thing. Nothing is going to ever change. And this entails to phone call, traditionally, the governments that, well, we made a selection of 6, but those that are part of the steering committee of the OGP to ask them with the agenda, with the agendas of their countries' organizations, to see what the changes that they could specifically do with regards to those topics were. And the questions, and I'm sorry, the calls here were for justice specifically, that relationship that is very useful. And we have a lot of questions around this, is the relationship of international dialogue with domestic dialogue, and those bridges that can be established with regards to the two from the perspective of different stakeholders has worked very well, and we have had a very good results, Nigeria and Kenya. Unfortunately, we have no Latin American country there at the steering committee. Otherwise, we would have done it with them as well. Data, we have got examples. Alvaro was saying this. Whose lab is a quintessential example of this, and we can be creative as to move forward and to have an impact on these initiatives. Thank you, Maria. Very well. So now let's go move now to Alvaro Herrero, and we will continue down with down the same line. Thank you very much. I agree with most of Maria's and the Justice's analysis. I think that the judiciary has got a structural problem which stems from its historical configuration of the judiciary in Latin America. The legacy of the Spanish tradition was a dispute resolution system, neutral third party, which was going to solve disputes between two parties. And this has an important role in the city because it is going to create a governance and social peace. However, with time, the judiciary changed with regards to their powers, their attributions, and we all know that the constitutional reforms which were broadening the judiciary's powers, the extension of rights in Latin America and in other parts of the world. And today, the judiciary is not only solving disputes today. This is a state power branch. It exercises power, and it has got power to contribute to the realization of rights, not just through its decisions, but it has got other tools and ways to contribute in the generation of equality in the society, the protection of fundamental rights. It can design its own policies in many aspects, gender, environment, housing, and we see how the judiciary today is ever more somehow they look ever more, and I'm going to say this with quotation marks, to the executive branches for some topics. So for the judiciary, in order for it to get closer to the citizens and to revert to the negative image it has throughout the region, and I'm saying this being part as well for the judiciary and having worked many years in justice, those of us who were inside, we know what is being worked inside the judiciary. We have a constant engagement by the judicial actors. However, the image is still negative. With the we still have a bad image of the judiciary's activity, and we are here in a justice paradigm focused on justice, what justice means and what people center justice means. And we have said this out of this conversation, this justice spoken in a language which is understandable for everyone, a clear language. This is a justice that will make decisions as a power based on data, on evidence. And if the judiciary wants to solve the problems of access to justice, it has got to consider which data are out there that account for the social needs, the violated rights. The judiciary usually does not usually do that. This is central to justice, and people-centered justice is egalitarian justice. Today we have topics that are at the center of the public conversation. For instance, the gender agenda. The judiciary cannot only protect women, girls, and adolescent women through its rulings. It can design structural policies to bridge its own gaps within the judiciary, and then go out into the society and lead a social change in gender matters. Today, we are seeing with the Castro Agreement a change of paradigm in matters of environment law and access to the environment and to justice and environmental rights. And the judiciary has a lot to do here, and it can learn from its own experience in other analogous fields on which it has worked together with the civil society. We have to work on how to connect the judiciary to the people. We have to think from the judiciary how to open this up. This is not to be requested by the citizens, by civil society. The judiciary has to set as a core goal to open up to society. Maria was showing whose lab experience in the magistrature of the city of Buenos Aires, and in here we try to solve problems, disputes which are related to the functioning of the judiciary and the protection of rights with the tools of an innovation lab. So when we think about solutions, not only we are going to be listening to the operators of the judicial system, but we're also going to be listening to the societies like the academia, the journalists, the CSOs, and that's what opening the judiciary up means. So, and that is, we have to stop thinking that the intelligence only on the judiciary side. We have to go out, look for that intelligence, and we have to start connecting neurons. So this is not just a matter of random. We have to generate coalitions, alliances to generate the knowledge that we need, so we can achieve that structural change within the judiciary. Today we have the judiciary planning in a participative way. We have very few cases, but we can use their experiences and take them to all the region. We have to think of a people-centered judicial system and what it means, and that's the main challenge that we have today. So we can make people fall in love again with the judiciary. Great, thank you very much, Alvaro. There is a lot of work to do, and a long way that we have already walked, indeed, with this knowledge that has been generated. Maria del Carmen, the floor is yours now. Thank you very much, Jorge. And, well, I am listening to what you are saying. And, yes, we have huge challenges, and something that Justice Margarita was saying with regards to the classification, to the operationalization of these transparency norms. I think that there are countless steps here to take, because we are speaking even about in terms of decisions in writing, but also criminal sentences that are recorded in video. And because of the orality, because of orality purposes. And in here we have to see how we can take one step at a time, so we do not overwhelm ourselves with what the institutional openness entails. Without a doubt, this is a way in which we can exercise the state institutions in a democratic rule of law. And I think that we have to take that into account, because institutional openness entails daily activities, not just the formalization of a pact or the execution of an engagement, but how we operate on a daily basis out of the state institutions, how we make decisions, how we document, how we can apply not just this right to know, but the right to understand, and the use of simple, clear, regular language. And language is also an important tool to generate inclusion, to have and to facilitate trust from people in institutions. And I think that open justice can be an important benchmark to contribute to the construction of a positive peace culture. Let's remember that anything that entails a search for the solution of a dispute, from the moment we have a dispute, we're going to be looking for a solution either by the judicial pathway, the judicial powers, and all of these broad spectrum of the justice administration institutions, in such a way that we have a huge opportunity to harness open justice for decision making and the daily operations from any level of structure, any level of bureaucratic institutions. And I would like to comment on a couple of tools that can facilitate this articulation, what we have in terms of open justice, because at the Commission of Transparency and Open Justice that I have the honor to coordinate domestically from the last year, we elaborated a newsletter concentrating different open justice materials. And in here, we are making them available, and they are publicly available in terms of any good tools. And then we can move to open justice. And also there is an article that we shared on how or under which circumstances open justice and democracy are today. And there is a journal, which is a new journal this year, so we can disseminate the challenges in this subject in the country. There is an article of open justice focused on democracy that is a very that it would be important to consider. And finally, how can we return to this step-by-step basis of small actions, between quotation marks, and the work with vulnerable groups, and how can we approach open justice to them? In the case of Mexico City, we work with women inmates, CIS and trans women, and we are detecting not just needs and articulating this narrative of offering solutions, collaborative, multi-stakeholder, multi-level solutions, and we have elaborated a guideline for identity transfer that will allow access to a different type of human rights exercise and guarantee. That's one example of how, with very specific actions and with no specific needs, we can take steps little by little in open justice in such a way that we can focus on how we can move forward and how we can what are the means we have to do this. And once again, thank you very much for this opportunity to be at this table with you. Thank you very much, Maria del Carmen. I want to thank, because we have run out of time, this topic. It has a lot of things about which to discuss, and not just in theoretical terms, now with regards to experiences, practices, and above all, with regards to experiments, models, and the projects that are being promoted today in terms of open justice. We have one task here and a very important matter here, which is that of judicial decisions, how to go from transparency to the generation of knowledge, public useful knowledge. and also the role of or the task of the identification and raising awareness before the stakeholders and the institutions of the judiciary with regards to all the revolution that open state means, not just in terms of judicial governance, but in terms of specific actions according to their functions. So we want to thank the public who was following this panel and who shared some questions with us. We're going to convey them to the panelists for them to follow them up. And once again, I want to thank the participation of Justice Margarita Rios for that, Maria del Caminava, Alvaro Herrera, and Maria Buran for having shared their knowledge and their experience with us in this space. Thank you very much and have a great afternoon.
Muchas gracias y buenas tardes a todos los que siguen.
Thank you very much and good afternoon, all of you who are following this third day of the Second International Forum on Justice Innovation. We will continue now with our next panel, Competences and Skills of the Operating People for Equality Justice. We will have as moderator Eduardo Martin Altamirano, which is the state coordinator of Justicia in the federal Mexican state of San Luis Potosí. We will have Lila Zaira Flores of the CEEAD, Javier Martin Reyes of the Judicial Studies Division of CIDE, and Luis Eliuta Bieldivares, who is a human rights attorney. I give the floor now to Eduardo Martinez. Thank you very much. Good afternoon, everyone. On behalf of Mexico, Evalua, thank you for being with us in the development for this panel called Competence and Skills of the Operating People of the quality criminal justice system, the change that the criminal justice has undergone from 2008 up to now. It has created a need for the operators to acquire new knowledge. And this knowledge quite surely have transformed and acquired different and new characteristics with regards to the institution that is involved in the long and sometimes tortuous process of justice administration in our country. Without a doubt, these have acquired new roles, and this also is determined by the regulatory framework for which the operators have been trained. And we should add to all of this the changes imposed by new technologies that while they have helped the criminal justice system significantly, it's also a reality that our operators need to know further these technological tools to operate with a greater efficiency with regards to their daily activities. We start from the next questions. We will start the development of new competences understood as that performance, which is the result of knowledge, attitude, skills of a person in a specific context to solve disputes that appear in different fields of their lives. And in this case, specific case of the context of achieving quality justice, this is something that we need to answer through this panel. If we need a constant training through new mechanisms, new tools to face a new criminal justice activity with quality. Another important issue here is the advances and interesting proposals that exist around our certification of our operators. What can we say, or what's the perspective about the use of AI in this case and the automation of some processes? This is another issue that we will try to answer here. These are just some of the topics that will be addressed by our panelists today. And with no further ado, I will give the floor, first of all, to Dr. Laila Zaire Flores, Certification Coordinator and Professionalization of the Center of Studies on the Teaching of Law, CAD, to share her opinions with us about all of these topics. It's a pleasure for me to meet you again, Laila, and I want to thank the CEAD with which I had the opportunity to collaborate for more than a year. We are great friends and great professionals. The floor is yours, Laila. Thank you very much, Eduardo. Thank you to all the Mexico Evalua team. It's a pleasure to be with you today and to share this table with people that I admire a lot. I'll try to organize my ideas, and maybe I'm going to do completely the opposite, but I'll try to order them. When I receive the document and the technical card for this table, I think that was the last topic you were covering, AI, whether there was any risk of displacement. And first of all, the topic on which I will focus is that of certification. But I'll try to answer this from what I believe. And I think there is no displacement risk, at least not in the short term. I was thinking about when I was saying this question, not just in the interactions that a person has with the justice system, but the interactions we have in our daily lives. And I was thinking about what happens when we want to when we have a problem with a credit card, an online purchase, an application, and you want to speak it, you want to talk to customer service, and you have a problem, and you send from one menu to another menu to another menu, and you find no answers because you just wanted to click star and get a person to listen to your problem and to offer a solution for you. And I think when we move this to the justice system, in which we have people with problems or who are subjects or victims of crime, or they are being accused, they want to find at their institutions someone who will listen to them and to their problem and to offer them the different solutions for thereof. So while there are processes that can be streamlined to reduce costs, times, discretional margins, and to have certainty for the institutional answer, so there will be many other more complex ones that at this time we would not be able to solve, especially when at our institutions we have greater problems when we think about technological equipment and infrastructure matters. So there are institutions who have got no internet or have no computer equipment that does not allow them to have the interaction that we're having right now through Zoom, because they do not have microphones, because they have got no cameras. Well, it's going to be very difficult to think about other technological tools. And there is an important challenge here. And something you were mentioning, Eduardo, at the beginning, is the relevance of the development of skills for operators in the use of information technologies, and not just for their work, but also for training matters. And in our case, what we have been doing from the CEE-AD, where we have a remote skills assessment through technological platforms, we have found some of the problems that people are faced with in the use of the platforms themselves, but also with regards to the other challenges that I was just mentioning before, which have a relation to the infrastructure and these people's equipment. Without a doubt, technology is offering opportunities here, and especially today with regards to training purposes and assessment purposes that we are working on. Virtuality has allowed us to reach more people, streamline, and while streamlining resources. I think that those of us who work in the teaching field, this new way in which we this new teaching mode brought about by the pandemic, we can see what the platforms allow us to have non-synchronous classes. Maybe people can better administer their time now. And now also we have the possibility for the operators to go to those trainings, because they are not going to be distracted from the hearing time, the time that they have to devote to assisting people and problems that they have in their daily work. And sometimes this is going to prevent them from attending to training courses like it's the case for other people. And sometimes the people who get more training are the people who are the least at the front line, because these are people who could be take some distance of, because they can take some free time of the daily activities to attend these courses. And in terms of skills and required for operators, if we start to think about what those skills are today, and we ask ourselves this, we will start saying many areas of knowledge, skills, attitude, as attributes that we identify as necessary as operators according to our own experiences and that we see as a need. And quite surely we are going to find a common grounds and common skills, and we will all understand that these are necessary to operate a good justice system, or that any attorney needs. Establishing these competences, I think this is the first step. We have to build the competences profiles, because in the end they become the benchmark or the cornerstone upon which we're going to be developing training programs, and how programs for staff selection are going to be working later on. And when we are speaking about processes and the definition of competences, the first thing we have to do is to work on those profiles per skills that are required for each and every of the judicial profiles and skills, because even if we have some common ground between the judges, the public prosecutors, the public defenders, there are specific skills that they require with regard in relation to their own role. So that profile cannot be only be made unilaterally or bringing a group of experts together just to define that. But this has to be group work, because the profile has not only a descriptive end in terms of the skills and competences that a person needs, but this is technical work that requires of an accompaniment of a professional, not just of a specific area, not just attorneys defining what we need to know to do, without an accompaniment of education experts, psychometry experts that will help us to define the competences, the performance standards and the indicators that can be observed and that can be measured and assessed. Because in the end, if these profiles and these profiles are going to establish the selection criteria or the performance assessment or training criteria, they have to be built in such a way that I'm sorry, I apologize for the noise in my room. I don't know if you can hear it, but there is a terrible sound from me. I'm sorry, I apologize for that. But that criteria that will allow us to measure and to be assessed.
the amount of people from different countries that are involved in this event. And well, I wanted to say 5 points, but I think I will have time for only 3. And I want to establish where I am talking from. I worked for a little bit over 8 years in the Center for Human Rights in Centro Pro, representing victims for the violations of human rights, victims of crimes and accused also, but also victims of crimes. For instance, the crime of torture. And after leaving Centro Pro, I have worked on the training for the operators of this justice system, especially from the judiciary at a national level, and also the general attorney's office in the country. And that's where my background comes from. And to try and answer some of the questions, I would like to say 3 things. I think I have enough time for that. First of all, it's about centrality of people and their rights. And I think that's an element that may seem obvious, but I think it's always necessary to put it on the table so that we discuss these topics. Access to justice makes sense only when it is about thinking of people regarding their rights, not only as if they are the users of the system. In this regard, the human rights perspective in the job of any person that is an operator in the justice system, whether they are a district attorney or the public defender or a judge, it does not mean that this perspective of human rights does not mean that it should be deficient. In a certain moment, I think that based on the reforms for human rights and the writ of amparo, we confuse the use of principles of interpretation as a person or a way of doing the basic process rules. This wrong interpretation had negative effects against the approach of human rights that characterized it as inefficient. If they don't want to comply with a process term, they mention the pro persona principle. And I think that we need this from the defense of the human rights. And I think this also has a certain part, because access to justice is complex, it's expensive, and it's difficult. And the reform would do the possibility of having access to justice in a proper way. I will close this part by saying that the approach of human beings for the operators of the justice system should be for the human rights, which doesn't mean that it should not be inaccessible or something that no one can understand. And there is a second point that has also had a lot of debates in the public space and social media. But beyond these rulings that are easy to read, we need to talk about the democratization of the judicial areas. I think we have the ethical responsibility of telling people this in a simple language, and also the translation of judicial technicalities to some people, because sometimes some of the operators of the justice system are reluctant to it. And I would like to give you an example that I saw working in the Pro Center. We did a report with a group of people from Universidad Iberoamericana, and we did a study on migrant women that were victims of crimes in Tapachula. And we visited them in prison. This was a woman, she spoke Mayan, and she had been there because she was accused of human trafficking. She didn't really know Spanish, and that's why we tried to communicate with that, or at least that's what we thought. In the conversations we had with her, she told us how she was forced to sign documents in the presence of an interpreter, and she didn't know how to read or write. And after 2 visits with the intervention of the university, we got a Guatemalan interpreter who spoke her language. And that day we discovered that she was happy, but she was happy because of what we did, but she was also mad because we didn't set her free. She didn't really know who we were. When she realized who we were, she changed her position in front of the group, and that allowed us to have a better intervention, to get to know what was happening and have a better option in her process and change the final decision. This is related to the language barriers, but this is also applicable for people who speak Spanish but do not understand the legal language. And when we talk about people who are understanding the terms of the process, sometimes they don't even know what is happening. Their expression changes, and that has an impact in their perception of the justice system, but also puts them as what they are as part of this process. And as I was saying, the responsibility to communicate the complex legal language or legal terms for all people is just in the hands of lawyers. Something that I don't want to oversee here in the Committee Against Forced Disappearance in the country, Mexico is part of this committee. And it's not just casually. There are thousands of people that are disappeared and that are forced to disappear by the government. And what I want to say is that for the judiciary, the reality that the disappearance of people has opened new conflicts against the judicial assistance that was not contemplated. And I put an example of the declaration of absence. And this has changed the way in which civil law has approached the new legal frameworks, a new interpretation that is being built. And I think it is necessary to train all the operators from the justice system in the topics that involve the definition of the judicial matters that are involved in this forced disappearance. I think that I run out of time. I can stop now and I can continue later to close these ideas. Well, we can stop for now and then we can continue with you, Luis. What you're mentioning is very important about the democratization of the legal language so that the whole citizenship can understand it. Right now, I'm going to give the floor to our colleague, Professor Javier Martin Reyes. Thank you very much for the invitation. It is a great pleasure for me to be in an event by Mexico Evalúa. We all know that this is an organization that has been at the front of many topics, not only for the specific topic that called us to this table, but I think that good part of the transformations of the justice system, specifically the criminal justice system that we have seen in Mexico, they have been addressed, studied, and analyzed from Mexico Evalúa. And I think that it is a great pleasure for me. Thank you very much to Cristel Rosales for the invitation to this event. I think that this is an amazing space to have a conversation. I am very glad to be here with people that I care for and that I respect. Some people such as Lila and other people that I don't know, such as Luis or you, Eduardo. And I am going to start because I know we have a very short time. And I want to set also the background for you to know where I am talking from. And the reform from 2008 created the need to have new tools and new knowledge for the operators of the criminal justice system. But I would like to address this in a more general way. I have the idea, and I agree with Luis, that not only the 2008 reform regarding criminal justice, but also the reforms of human rights and amparos in 2011, I think that many of the deficiencies that we had in the training and in the practice of the judicial operators, I think that these deficiencies are the main obstacle that we have so that we can do more interesting things, such as the use of new technologies, or as it would be the incorporation of artificial intelligence tools as it was established earlier. And I'm talking about other experiences that are very personal, but I think that they have something to do with how law is applied in Mexico currently. I worked in the judiciary for almost 5 years. I was also in the election court, and also in a regional area in Monterrey. I got to know the amazing work that the CEA does in these judicial matters, and I had the responsibility of coordinating a work group from one of the justices in that area. And something that we were able to do is part of the work group from the previous justice, who had great experience and great knowledge. These were people that were 40 or 50 years of age, and they had been working in this electoral justice system for more than a decade. And these were people that were doing their work in a very good way. But I think it was also very obvious, since we started drafting the first bills in that room, that there were a lot of deficiencies. And I will set a couple of specific examples. I remember that we got a case, we took that to one of the collaborators, and then we got, after 5 days, we didn't have anything, and then after 2 weeks, we didn't have anything. And in electoral matters, the times are very short, and we need to do that as fast as possible. And after talking to her, she told us that she was struggling because this complaint had a problem on a regulation that was being contested. And this seemed to be a relatively easy case for us, because we had people that were in the Supreme Court, and we knew that this specific type of regulations in other states were based on the Constitution. And she told us that she had never done a study like this in the more than 15 years that she had been in this system. And this court, since 1996, has these cases of constitutionality. But this is something very basic that we should see in a class regarding the theories of law, and she didn't have that. And I also was able to work with a very good lawyer, and what he had, I don't want to mention his name, but he had something that was only a collection of pre-created paragraphs, and these were dozens of pages, and he copied and pasted the paragraph that he thought that was the best option to answer for the concepts that were established in that plan. Once again, this is an idea, and he said, well, these are the criteria, so I have these other criteria, and I'm just accommodating it according to what I believe. And that's the idea he had on how this was done. And this was the second personal experience that I wanted to share. For 4 years, I have been a full-time researcher professor in CIDE. For 3 years, I had the opportunity to coordinate this law program. And I think that many of the solutions to the problems that we have right now with judicial operators, and that are the foundation that allows us to do more interesting things is within the education that we have. I think that continued education is very important in specialties, master's degrees, postgraduates are very important. But if we do not solve fundamental problems with educations from the root of the degree, we are going to have problems. So since CIDE started and was born in 2001, it was open as a anti-formal program. And by that, I mean that we think of three things. The first thing is to understand that law is not a static phenomenon. It's a dynamic phenomenon. And with this, what we mean specifically is that learning about law is not only about memorizing a group of regulations and concepts, but we need to see law in action. The blog of CIDE is called like that because what these judicial operators are doing, or what is being done in the specific areas. We cannot learn criminal law just by reading the Constitution or the National Code of Criminal Procedures and the local codes. We need to see what the practices of the operators are. And also, I think that from CIDE, we have always tried to understand, or we have defended the idea that law is not only an abstract group of regulations that are not related to reality. There is a factual reality that we need to understand, and that's why we need to give the operators some minimum foundations of interdisciplinary knowledge. And in constitutional law, students at least need to find something about political sciences. If they need to understand something about economy for them to understand the market that they are trying to regulate through these regulations. If they want to do criminal law, they need to know about criminology, sociology, something about empirical studies. And the third thing, and I will close with that because I know that I'm running out of time, I think that in CIDE and in other places, and here I'm speaking from my personal experience, and I know that there are a lot of institutions that are also doing these things. The third point that is very important for me from this experience is understanding that lawyers cannot be experts in everything. I always give the example of an idea that was already overcome, fortunately, is this old study plan that existed in the 90s. It was around 10 semesters with 8 subjects each semester, and in the end, lawyers ended up studying 80 subjects of only law. From the first semester, we only studied the regulations, and that's it. I always give that example, but in that study plan, one of the mandatory subjects was agricultural law. And I don't say that this is not important, but it should not be a mandatory subject for everyone. I think that criminal law is a very good example as well, but we need to bet on lawyers that have a very robust and strong foundation of knowledge, that know about philosophy of law, that know about procedural law, constitutional law, and all types of law. And after that, then optional subjects in which the students are able to learn by themselves. Because what we are seeing, and a great part of the challenges that we are seeing in the operation of the criminal justice system, is the difficulty of the people that were trained not only with an old paradigm, but also people that were not taught to learn by themselves and adapt to the new realities. There is this idea of thinking that law is something static, that there are concepts that cannot move, that come from Rome and can never be modified, not even by the legislator, nor by the reality. And well, those were my examples. I will leave it there. And I'm sorry because I know I took a couple of extra minutes. Don't worry. Thank you very much, Javier, for your presentation and for sharing your knowledge with us. I wanted to ask I would like to tell the 3 speakers, I am told that we are running out of time. Each of you will have around 4 minutes to answer 2 general questions. And if we have a bit more time, we might be answering the questions that we have from the people who are participating in this panel. Now, the first trigger question that I would like to give you is, what is the relationship between technology and the justice system workers? I think that there is a risk of displacement. I think that is a very general question that I am presenting. And also, what is the way to ensure the good performance of the operators of justice? Should there be a constant certification? Maybe Lila, you can talk about it. Well, I'm going to speak the first one because I think that I gave my opinion at the beginning of the conversation. I gave my example to customer service. And now regarding the training or constant education, continued education, I'm going to take 2 of the ideas that my colleagues mentioned, and one of them is access to justice and how competencies or the professionalism of those who operate the system, it can become a barrier, an obstacle to access to justice. And we need to face this responsibility of those who are intervening in the training of lawyers to guarantee that they have the competencies that the society requires when they are facing a problem that requires a lawyer, and the interaction with the justice system. Because in the last few years and the reports that we have obtained regarding the experience of the users of the justice system, we see that despite the amount of lawyers that we have in Mexico City, the needs are not being met. And also regarding the judicial education that Javier was mentioning, I think I can only agree, because many of the issues that we see in the operation of the system are a reflection of what happens in the classrooms and in the education, which we are reproducing constantly. And that's why it's also important to reproduce profiles. We have a profile per competencies, because if we define what we are expecting from a lawyer who is a judge, and what do we expect from a person that just graduated, we need to see the experiences that they have had since the moment they entered the major, and what are the competencies of the university when training them with the people that just graduated, and the competencies that they are going to develop during their professional life so that they can comply with the things that they are expected. So I think that we need to establish the definitions of what we expect from them and then talk about the profiles. And starting from that, maybe we can start working with what we are doing with the certification processes of professional competencies according to the judicial competencies. It's not just a general certification or training. We could do that because there are competencies that are common of all graduates, but how important it is to establish rigorous processes of assessment for people in general. I mean, judges, defenders, etc. And I think that's my reflection because we are running out of time. Thank you very much. Thank you very much, Lila. Now, Luis, please. Thank you. I think that I can connect my comment with Lila so that I can answer the trigger questions regarding the cases of disappearance. What I was saying is that due to the forced disappearance situation that we have in the country, the operators, and in this case, I'm talking specifically about the judiciaries and the operators of the justice system, require competencies that they did not have. They didn't know about the use of technology for the search of disappeared people. So right now, the control courts need to solve or decide on topics related to the search. If a general attorney denies a search or refuses to use a certain type of technology, the family of the disappeared person will go to a resource in court to request the use of technology. These people need to have the competencies to know that we have these type of photographies, that there are your radars, drones, and also to know about forensics and topics that were not in their ideas before the situation. And I think that this agrees with what Lila mentioned, because not all operators in the justice system require this, just a few of them. So we need to choose the training that is appropriate for the person that is going to use it eventually. Maybe a control court in a specific matter that is the one who is going to talk about it especially, for instance, or the writs of amparo that are going to be used by some cases. Not only a certain specific amount of courts are going to use this type of amparos, and they are not all going to have the ability to get this training. And something that I think is very important, and I think that Mexico Evalúa mentioned it very well, is that we need to talk about the judiciaries, because sometimes we talk about these at a local level and sometimes at a federal level. And we say that all trials end at the federal level. And I think that they should all end up in the federal level, but they don't. Most of them end in the first part, and just only of them reach the second part. And being able to see the judiciaries that are solving most of the cases, I have been seeing statistics in Mexico City in civil matters and in family matters, and more than 85% of the cases in the last 5 years were solved in the first institution or in the second institution. And none of them, of the others, went to Amparo, and these first institutions are the ones that are deciding. So I think it's important to see the courts of the different states for them to acquire all these competencies in relevant cases, such as the ones that we are mentioning. I would leave my presentation here. Thank you very much, Luis. And please, Javier. Well, just quickly, regarding the first question, if there is a risk of displacement, I think that I agree with Lila. I think that the lawyers are not going to stop working. But I think that the way in which we work is going to change. And I would like to give you some examples. The justice operators developed a function to create rulings that needed to be transcribed. We needed to transcribe what the complaints say, the different types of documents. And there were people who dedicated in a good way to that. Sometimes they were majored in law, and sometimes they didn't. But we know that this is something that has disappeared, because right now it's easier to do a copy paste. And this is a technological change that we have seen. But if we think about all of this, I think the same is going to happen. In many justice systems, and we should not talk about the branches or who is right, we should also talk about the justice system, not only the systems, not only about one system. And technology is saving a lot of time, and they have changed the work that the way that people in the justice system work. And there are different examples when we are trying to search for previous cases, and people took time to go to the different documents to search for some criteria. They had to invest a lot of time on that. And since we have the use in CD or right now in a web format, the time that we dedicate to that is shorter. But that doesn't mean that we should not dedicate time to that. And I would say that with the reform that was just approved, one of the changes with a great potential or that has an impact in all the areas of law is to understand that the judicial precedents are not just some paragraphs, are the mandatory criteria that are in these rulings. We need to learn to read them, to see what were the decisions, what these terms mean, what is mandatory, what was not mandatory. This is a skill that we need to develop, that we need to learn, and we are going to have a lot of work there. For those who want to develop technology systems to make it easier, we are going to have people behind that. We're not going to solve that with artificial intelligence. And I also think that in a different level, I think that we understand law in a very different way compared to what we thought before. We do not understand that as a finite group of rules, because if it was only logic and it was only about finding a rule that was given by the institution, I think that our work as lawyers would not be at stake, because we only require a programmer that helps us to establish these pre-existing rules. But what we know right now is that law is undetermined, is vague, is ambiguous. It needs to be built, and for that we need argumentations. And behind these argumentations, we have values and we have positions where we have to be very honest. And I think that the operators, we have a great challenge and a lot of work. Right now, to build the regulations from which we are solving matters, we need to do more than only looking for specific rules in the code. And also, I think that operators really need to have a better training in law, not only to learn about the laws, but to understand that the facts are not only in the regulations, and we all have great challenges. I think that we are not going to be replaced, but I think that we need to improve our training. Thank you very much to our panelists, Lila, Luis, and Javier. I want to ask a final question, and these are some of the questions that our audience was establishing, and it's how to achieve that these trainings in human rights are internalized and applied. This is the only question that I chose because we are running out of time. I would like to hear you very briefly. I would like to hear your opinions, whoever wants to take the microphone. I can say something very quickly, and I think that Lila has more to say, but I think that one of the ways that has to do with the indicators of result, it's also related to relating the incentives in this career. I think that this is a simple way of having the training and then having a specific and direct consequence, a benefit for the person. But I think it also is related to the follow-up and the decisions of these people, which was to train them, because it means I went to a training and now I know how to use these tools, and then they are reviewing my rulings, and it has nothing to do with what I saw in that training. And right now I learned about an amparo that on forced disappearance, and if the person is not here to ratify in 3 days, then it means something. So these type of things need to be done to measure the real impact of these trainings in our everyday work. And I think that this is on the side of the judiciaries. And I would say that the international organizations on human rights, right now, they are starting to ask the judiciaries, and they are telling them to show them the numbers, the examples that they are complying with the trainings, and that these trainings are effective and have a direct consequence on the rights of people that are using the justice systems. That was my answer. Well, if I may very quickly, and talking about different dimensions, I think that the whole reform on human rights, and there is a speech that had affected it, and it may seem very simple. I think that there are different speeches that have made the use of human rights trivial, and I would say that human rights are positive law, and today an operator of justice cannot not know about human rights, and I think that we need to change this idea. And this comes from the past. If we think that constitutions are just letters of good intentions and that they are not mandatory, we are going to be in trouble. I think that when we start internalizing that these principles that are in the first article of the Constitution are translated into binding regulations for all judicial operators. If we believe that, then everything changes. It's not about just avoiding a ruling or having a ruling that is good and looks pretty. This is translated once again into regulations that we need to establish and incorporate. I am afraid that some of the changes in law are really slow, and they happen because of the changes in the generations. I think that it's not only about the operators that have the greatest responsibility, but also from their work teams. If we talk about the rulings of the court on, for instance, abortion, and we compare them to what was established 10 or 15 years ago, this way or this new way of understanding things is not only result that the justices changed and they think differently, but also because their teams are younger and they have internalized this logic and they know how to operate with these tools, and as a consequence they are willing to do it. So I think that what we need to bet on is the training, and yes, we need to try to relate them in the proper way with assessment systems. But if we do not bet on training and a slow renovation, we are at risk of looking like making human rights is making justice, understanding justice as the morality that each person has. And sometimes we believe that it's like that. We put human rights as if it was something different than law. So I think that's one of the things that we need to do. Thank you very much to our speakers. Thank you very much, Lila, Luis, and Javier, for giving us all this knowledge. I am being told that we run out of time, so we are going to close this panel on competencies and abilities of the operators. We may continue talking about this topic for hours. This is a very huge topic, and we can relate this topic to a lot of other criminal justice issues in which we can be involved, because it involves all the institutions that are in charge of the administration of justice. And they mentioned the importance as well of the respect that needs to be shown to human rights, as you all mentioned. So in this case, I will give the floor now to our presenter.
Muchísimas gracias a todos los que nos están siguiendo en este segundo Foro Internacional de Innovación en la Justicia. Agradecemos al panel que acaba de concluir sobre competencias de las personas operadoras. Y a continuación, damos paso a la clausura y cierre de este foro, invitándolos a que puedan seguirnos en nuestras redes sociales, en nuestro canal de YouTube, y visitar nuestra página www.mexicoevalua.org. Para la clausura y el cierre, nos acompaña Edna Jaime, directora general de México Evalúa, María José Salcedo, de la Fundación Friedrich Naumann para la América Latina, Olga Regina García López, presidenta del Tribunal Supremo de Justicia de San Luis Potosí, y Ernestina Godoy, fiscal general de Justicia de la Ciudad de México. Doy la palabra a Edna Jaime.
Now I give the floor to Edna Jaime. Thank you very much. Thank you, Enrique. It's been 3 days of intense work in which very transcendental topics were addressed both for the present and the future of justice. Actually, I warm-heartedly, I thank all the participants of the event for their time, for sharing their ideas, for their reflections around all of these topics that have got to be a central public agenda, how to adopt digital technologies in the enhancement of the state's administration and justice response, how to achieve responsive institutions, that is how to increase the responsive capacity of institutions faced to the service demands by the citizens, and in other words, how to increase justice quality. And this concerns everything that I have just said by using innovation. Throughout these 3 days, we have discussed about many topics, about the big advances in terms of AI and the limits that it can have in justice administration. Throughout these conversations, it was highlighted that the automation and prediction of specific processes can be a support tool, but not a replacement of the judging people. We also discussed about the health emergency by COVID-19 accelerated and expedited the adoption of technologies and digital tools for the improvement of management and to facilitate access to justice. At several tables, we discussed the dilemmas and risks in the use of technologies and how our information is managed and protected, cybersecurity that is, and which measures we have to adopt and how we can move forward in a culture of data protection and of awareness of our digital rights. We spoke as well about intersectionalities and the proposals that can be implemented to bridge the gaps and inequalities from the gender perspective all the way up to the inclusion of groups such as migrants. We analyzed the climate justice challenges and the potential of alternative justice. We spoke as well of impunity and of the different ways to face it. This is a very current topic in today's Mexico. The first conclusions, I have to say that we have to process this information, have to go over the panels again, and we have to take the most powerful ideas to present to you later on as a memoir or as a video, the findings and the most relevant conclusions. However, allow me to talk to you about the learnings and what draw my attention the most, how every technology being adopted must place at the center the people. This is not about playing with technology just for the sake of it. It's about using it to better serve. But any innovation must acknowledge the huge gaps that exist today. It seems that in today's digital world, this is some kind of illusion, right? In the world, in the non-virtual world, in we have big gaps, and it will be amazing that these are disappearing in the digital world, but no, they exist here as well. And every innovation must acknowledge these gaps. So they exist, and also in the digital world. And this must be a topic for discussion in terms of justice innovation. Innovation must entail the bridging of these gaps. So, person-centered justice, improvement of quality of life, innovations that allow for the interaction between the citizens, the civil society, and the authorities, innovations that bring services together to demands, brings closer to demands and actual demands. Out of all of this, about all of this we discussed throughout these 3 days, and an important element that has to go hand in hand with innovation is open justice. Without it, it would be difficult to move forward around innovation that we are considering throughout these fora. We have just to put these discussions to the public. Finally, our conviction, this is in a real change, operational change. That's why within the framework of this forum, we wanted to take specific problems and propose innovative solutions to show that these discussions do not belong to the ideal world, to the abstractions world. These are replicable and duplicable. I have the great honor to tell you that for this closure, there are people that I respect and appreciate a lot. I will start with Ms. Maria Salcedo. She's coordinator of Mexico project of the Friedrich Haumann Foundation, whose support has been pivotal and decisive for this forum to be held. I want to respectfully greet Judge for the Supreme Court of Justice of San Luis Potosí. It's a pleasure to greet Ernesto Negroy, Attorney General of Mexico City. And she's always ready to be with us because she believes in innovation and in transformation for good and for the good of the Mexicans. Thank you very much, Attorney General. And now I will give the floor to Maria Jose Salcedo for her to address her closing remarks. Thank you. Thank you very much, Edna. I also want to greet and acknowledge and thank for being here at the closing of this space with such women. And I want to believe that innovation and we as women can also promote something around the topic of justice. And on behalf of the Friedrich Haumann Foundation, I want to tell you why we decided to bet on innovation. And as Edna said at the beginning of this forum, the consequence of the pandemic and the lockdown situation made more evident the need to digitalize not just the economy, but also the public institutions to have an economic reactivation. It's nice to have a reactivation of human rights and governments, not just in Mexico, but throughout in the world and even in Germany. And I'm surprised when I'm asked that even in Germany, there is a crisis of institutional agility, where obsolete technologies are being used which are insufficient to face technologies that nobody could have foreseen, as is and continues to be this COVID-19 pandemic. And at the same time, bureaucracy and the systems that we have, not just in Mexico, as I am telling you, all around the world, the 20th century, and to face the 21st century challenges, we have to consider the aspirations of the new generations that are born being digital. And this obliges all of the systems to think about the future and the citizens that we have to attract so they continue thinking and believing in the future of a country. Without a future vision, that talent will leave to a country that can offer them better opportunities. And it's necessary for our citizens and for us as Mexicans to believe that there can be a future in Mexico. From the foundation, we're betting on innovation because as a liberal foundation organization, we are always wondering how we can promote and strengthen the rule of law of democracies in a more innovative way or differently. Promoting the rule of law market economy is concerned, the collaboration in which we have the relation between the government, the governor, the governing bodies and the governees, and this has goes to be a tool of approach. And we know that technology can polarize societies or can set us apart, but also it can be the mechanism that can bring us together. And these were 3 days of amazing ideas to convince ourselves that technology is the mechanism that exists and that we must use it for dispute resolution through which we can recover the social tissue, which is so necessary in countries such as Mexico. And at the same time, it's important for technology to continue progressing and that a new international challenges arise. Technology will continue to streamline. And as Chris said throughout the tables of the forum that I had the honor to moderate, like that of impunity, it doesn't mean that we have to use technology all the time, but we have to think about doing things so differently and not just to come up with the new black thread of things and practice that throughout these 3 days have become and represent an opportunity for operators, members of the public sector, the civil society to exchange those ideas. And even if we know that the burden is huge in Mexico, technology and those tools are there to be used and to expedite processes. But also something that I'm going to taking from the last panel is that the members of the academia and students must rethink and update the syllabus, the syllabi, and internet, big data, social media, and everything that can support in a justice administration. As I was a student, and I'm surprised that the syllabi remain the same, the curricula remain the same, and that's why even if the justice system is lagging in Mexico, we can see how technology can help us to reduce corruption, impunity, and open that communication between operators and the citizens up. And actually, the truth is that I want to thank Mexico a lot for all of their efforts and their endeavors in organizing and the selection of the panelists, and also the team in Mexico because of all of the organization needed for these fora, and also the technical part. So this was available for you on YouTube and for you to enjoy this. And as Edna said, let's continue looking for resonance space. This must not remain here. Take it to your tables, to your classrooms, to your authorities, and it should not just remain here. And let's continue looking for spaces of dialogue. Thank you. Thank you very much, Maria Jose. The truth is that you have made us all very excited because innovation has good indeed a technological aspect to it. And I think that as civil servants, as members of CSOs, we have to look for the public policies, for the government responses, for the relationship between ourselves, to look for innovation, to find more efficient solutions to our common problems. So I'm happy about, I'm excited about your enthusiasm, and we share this conviction. And the foundation has it very clear as a goal in its agenda, and this makes it possible for us to continue promoting our own goals of our own agenda. And it's good that we have common points between our agendas. Now I want to give the floor to Judge Olga Regina Garcia Lopez. Judge, thank you for being Your Honor. Thank you for being with us today. And it's a pleasure to have such a representative of the judiciary, because I would love to listen to your perspective with regards to what was discussed throughout this forum and the role of innovation in the work of judges. The floor is yours. Thank you very much. For me, it's an honor to be today on behalf of the judiciary of the Mexican Federal State of San Luis Potosí, and to have this opportunity to greet Professor Edna Jaime, Professor Crisel Rosales, Maria Jose Salcedo, and especially the Attorney General Ernestina Godoy. Today, we are here as women representative of the different fora and for the different trenches from which we are working. I think that this innovation forum which Mexico Evalúa has been concerned about technology and progress, but also about the human side. This has been highlighted throughout the talks that we have had throughout these days, and I fully agree. In Mexico, as we know, since 2008, we have had substantial reforms that have changed the way and the perspective from which the ways in which and the perspective from which we judge. And now this COVID-19 pandemic made it even more clear that concern for new tools, new technologies. But now it was evident that we had this need to streamline the judiciary, because this will allow to bring justice closer to the citizens, and this will allow us to breach those gaps. And today, the largest share of the public can be in trainings and even in the judicial hearings that have been developed. I think that it's common to all the Mexican courts that draw on the technologies that we were already using, and the way to administer justice was reinvented, because we know that sometimes technology is not so accessible for everyone, and for the courts themselves, that this was quite complex, and it remains so, and it remains a process that we are undergoing. But I think that our will to continue administering justice and not to lose contact with the users made us do a lot with the little we had. So in the state of San Luis Potosí, we were conducting video conferences, activities with minors, because we did not want that harmony to be broken up between parents and children, because they had the right to see their parents, and the pandemic did not allow for this material closeness. And in the state of San Luis Potosí, this worked, and these family activities worked very well. And also in terms of civil mercantile cases, and also this allowed us to have platforms, and we never imagined to have users 500 users listening to a speaker of high-level speakers who were training our staff, because that was the other side of the technological coin. We had to train all of us to learn to use platforms, Zoom, and how to communicate, and the staff was attentive. I want to acknowledge them, and through my voice I want to thank the staff of all of the courts who learned to move from a reading and paper to the use of technologies. We had a very positive elements and tools that facilitated that justice administration. Likewise, this allowed to identify needs in the most remote places. For instance, in San Luis Potosí, we still have indigenous peoples who speak Tenec, Huasteco, and this highlighted the need to bring this technology closer to the most remote communities of our state. Gender perspective is being applied, but it must go hand in hand as well with technology. Otherwise, it will not reach those remote places that our vulnerable peoples need so much. We have a lot of hope that these strategies that we have been developing at the court generated that closeness. And in our case, it's generating justice facilitated to be present through technology and to communicate and how to hold our hearings because we have a labor justice since last year, and it's been a year now. And resources weren't enough to reach all the municipalities. But with this, through video conferences and through what we call itinerant traveling justice, we were able to reach them, and this was very motivating. And I know that there is a lot to do, and court we're still undergoing this reinvention process. But I would like to acknowledge each and every one of the judiciary, and we are sharing some of the platforms of the tools that we were using, because this improved unanimously at the national level. Of course, I celebrate this type of encounters that allow us to expose the innovative ways for justice administration, and also it concerns the future challenges to and we have to guarantee more and we need to guarantee more expeditious trials. Thank you very much, Judge. I'm listening to all the advances you have had and how they were expedited by the pandemic. And in Mexico Evalúa, we have a series of documents that concern the innovation and good practices in digital justice. We are working on some guidelines to direct those judiciaries that are only starting this journey, and how they can take very sound steps. And we are also conducting a diagnosis. So we have an idea of where each judiciary is in this process. And we have a series of documents that we are going to which we're going to add the learnings of these for us. So we are building a very good base of good practices and knowledge of practical exercises. And I think that little by little, this can help us transform deeply, always bearing in mind that we have to bridge the gaps. That's my main concern in terms of the digital world. And let's not bring inequalities in access to justice to the digital world. Thank you very much, Judge. And now I want to give the floor to Attorney General Ernestina Godoy. You know how much I appreciate your presence here with us for this closing. And I'm going to be very happy, and all the public, of course, to listen to your perspective with regards to justice and innovation, and with regards to your own initiatives in this field. The floor is yours. Thank you very much. It's a great honor for me to be at this closing table. I greet my women colleagues of this table, Maria Jose Salcedo, Your Honor. Thank you very much. It's a pleasure. And above all, I want to thank Edna, because she's always thinking about the Mexico City prosecutor's office. And I completely agree with the vision of those who organized and coordinated and took part in at this forum with about justice innovation, and that innovation has to be present all the time at the institutions that are responsible for guaranteeing access to justice for people. As some of you know, because I have said this everywhere I go, Mexico City's Public Prosecutor's Office has been for 2 years already in a transition process towards a new justice administration model. We inherited from the past many inefficient working ways and an institutional culture that did not prioritize the protection of people's human rights and the effective dispute resolution. One of the goals of our transition process is to streamline all of the activities of our institution, including the reception of complaints, the management of cases flow, the segmentation towards the different types of solutions or responses, the distribution of the institutional resources to achieve criminal policy goals and the coordinated work with other justice institutions. Moreover, technology must be a key element in improving investigational techniques by our technical staff. And also, we need to look for efficacy, but also good service and protection of human rights with a gender perspective. I want to tell you how the innovation and the use of technological advances are helping us in this transition and how we are planning to continue this streamlining. One first way to streamline this is data management that has become a core tool for our administration. We have created a statistics and transparency unit with which we have enhanced our databases and our methodologies for information analysis to better understand criminal phenomena and to monitor the acts of our staff and to measure the efficacy of our investigations and to assess our progress and results. Thanks to the management, to the data management, we better understand opportunity areas of our work in our offices. And with this, we can design reforms for our processes and organization ways. We are building differentiated answers for the way in which we address cases and directing some to non-criminal solutions and prioritizing the use of investigation resources to prosecute gender and high impact crimes according to our criminal policy. Another streamlining process is the search for the improvement of case traceability. That is the capacity to know at all times who are the responsible for these and the stage at which they are, the investigation activities have been conducted and what the results of these have been when they are sent to other areas and when determinations and other formalities are conducted. And thanks to this, we have been able to identify gender violence cases which are ready to be tried, but that had been lost in the sea of open cases. And we have also been capable of detecting and sanctioning corruption cases of abusive acts against users or against the accused people. In the future, we plan to continue developing technologies that will allow us to better understand criminal phenomena from maps and scoreboards that will allow us to study incidents in real time all the way up to analysis technologies for the investigation through patterns and case association. A third streamlining process that is outstanding is the digital investigation file. Right now, most investigation file and ministerial investigation files are in writing. Furthermore, to request the actions by other units or to transfer the case to another person, we must send a messenger with the folder and the investigation file in writing. So that's one of the reasons why the citizens think that the Public Prosecutor's Office is inefficient, and that's why people have to go from one agency to the other without receiving information about the case, without exactly knowing who is the responsible for this investigation. We are about to finish this year, and next year we will start with the implementation of a new platform called Justice Comprehensive Information System, SAIC Spanish acronym, and this will allow us to manage investigation of files in a completely digital way and to reduce the use of paper and to facilitate communication between the public prosecutor offices, investigation offices, expert offices, and to connect this to the judiciary and the civil security agencies to facilitate information exchange and the efficient realization of formalities and processes. We believe that this system will improve our capacity to provide a good service to the citizens. I want to mention some advances in terms of innovation and streamlining in crime investigation. The project with the greatest scope we have undertaken is the DNA Bank, Mexico City DNA Bank for genetic profiles. So this bank that has already been built, that is already equipped, and that is in the process to be certified, will have the capacity to process all the way up to 6,000 genetic profiles a month with the strictest standards internationally. Our investigation police is in the process of a very deep transformation, and this will go through the improvement of the agent's profile and the use of tools. And that's why we have invested in equipment and tools to create a Directorate General of Intelligence that had not existed before at the office. And this will allow us to create network links that would be fit should we need to do them by ourselves. And this is going to help us in the clarification of cases. The prosecutor's office does not consider streamlining as an end in itself, but as a tool to achieve our core goals, to place the victim at the center of our work and to address social demands of justice and security, and to find criminal phenomena ever more complex. We must boost the characteristics of the autonomy of the justice administration institutions for the designing of innovative mechanisms and tools that may not be so traditional, but that will allow for a greater access to justice for citizens in an efficient and simple way. I hope that what we are sharing with you today will help us further, and will help further all institutions to join the streamlining, the innovation of access to justice, the justice administration that is our responsibility, but also the justice administration that is the responsibility of the judiciary. I thank you very much, and I congratulate the organizers for such a necessary and appropriate event that will ring the start for all of us to improve our work, so we can continue opening the doors of justice up to the citizens. Thank you very much. Thank you very much, prosecutor. You say, I think a lot of Mexico City public prosecutor's office, and it's true because I have a big expectations about and for your transformation. And what you have presented today just confirms or sustains my expectations. So congratulations, prosecutor, and thank you very much for having been with us for this closing. And well, I just have to close this event. And I want to thank everyone who made it possible. And I'm speaking about the researchers who took part in this, experts, and also the teams both of Mexico Evalúa and from the Friedrich Haumann Foundation, which invested a lot of energy and were convinced and believed in this edition, and that made it possible for this edition to fully achieve its goal. And we are putting at the table very important topics. And I hope that what we have just discussed and the specific points that were elaborated throughout this reform can become a justice transformation agenda for the country. You listen to the judge, to the public prosecutor. This transformation is ongoing. And believe me that I think, and I have said this a lot, that should we manage to transform our justice, this country will change forever. And what we want is to offer more discussion elements, more available tools for this to be a possibility. At 5:42 p.m., Thursday, 18th of November, 2021, I officially close this second International Forum of Justice Innovation, and I wish that its goals have been fully achieved. We see you next year for a third edition. Thank you very much, everyone. Thank you. Thank you.
Muchísimas gracias a todos los participantes, a todos nuestros ponentes, panelistas, a todas las personas que nos siguieron a lo largo de este segundo Foro Internacional de la Innovación en la Justicia, organizado por México Evalúa y la Fundación Friedrich Naumann. Les agradecemos a todos su tiempo y pueden seguirnos en nuestras redes sociales, en nuestro canal de YouTube, en nuestra página de internet www.mexicoevalua.org, donde subimos nuestros análisis y propuestas de política pública. Que tengan muy buena tarde.